Okay. All right. It's now 10:02 on Friday, February the 26th, 2021. The meeting will come to order of the Behavior Analyst Advisory Board. The board members are asked to unmute their microphones while Ms. Luna calls the roll.
Thank you. Dr. Joyce Smith,
Present.
Harold Sloan,
Present.
Dr. Stephanie Sosowski,
Present.
Laurie Snyder,
Present.
Amanda Nichols,
Present.
and Dr. William Borland.
Present.
We have a quorum.
Thank you. So with that, we'll proceed with the agenda as previously distributed. First item on the agenda, item of business coming up is item C, approval of minutes for our meeting, November the 4th, 2020. That was our most recent meeting. Any comments, recommended revisions on that? Amendments? Anything? I have one to suggest. And now I've lost my place. There it is. I'm looking at the second full paragraph there, which begins presiding officer Dr. Gordon Borland moved to agenda items G. This is the reports, specifically item 2 within that, the licensing group. I'm sorry. I need to correct myself. It was the paragraph above that, the first full paragraph. Presiding officer Dr. Gordon Borland moved to agenda item F, staff reports. Skipping down toward the bottom where Mr. Nizami and Mr. Russi presented the enforcement division report and answered questions from the board. There was discussion there regarding, actually there was a request for some additional information to be provided, primarily regarding the complaints and things of that sort, and the resolutions of them, time periods for addressing some of those complaints. And as I recall, I believe it was Mr. Russi said that they would certainly look to ask, would we like for that to be information to be included routinely? And the answer was yes, and he said he would. And I just point out that he did follow up on that this time around. But I recommend that I submit that as a recommended addition to the minutes. Any discussion or comment regarding that? Hearing none. And let me remind you, when you speak, please be sure to say your name first, or as soon as you remember to say it anyway. Is there a motion to accept the minutes as amended? Dr. Mott moves. Is there a second? Second, Dr. Sokoloski. All in favor of approving the minutes from the November 4, 2020 meeting, so indicate by saying yes or raising your hand, whichever one. Okay. Did you get the count, Ms. Luna? Okay, here we are again.
I did.
Okay, thank you. Okay. I believe the minutes are, Dr. Sokolowski? Can't hear you, sorry.
Now I'm trying to do this. I've got a question. Are we going to share documents, or do I need to pull up my file, my document that was sent to me? I'm glad to do that. I just wondered. I mean, do you hear what I'm saying? Do I need to pull mine up so I can follow along?
No, you can look at your documents, but the staff reports I'll be sharing.
Okay.
And sharing my documents for all the staff reports. When you give your document, you can, read off of it. Everybody.
Look at me. I printed it 18 font so I can see it.
Okay, perfect. When
So, okay.
Dr. Borland will call you when it's your turn, and then you can read your report.
Yeah, excellent. Just to be clear, Ms. Luna, did the motion to approve the amended minutes pass?
Yes, sir. And it did pass, and I apologize. Motion passes, yes.
Yes, okay, thank you.
Everybody approved. Mhm.
Zipping right along to the next item. D, public comment. The Behavior Analyst Advisory Board did receive 3 public comments. They have been distributed to the board. I believe all the board members have received those. I trust you've read those. The public comments will not be read publicly. And we did not have anyone who wished to speak under the public comments portion of the meeting. With that, I think we're ready to move on to item E on the agenda, staff reports. First up is the licensing division. Ms. Hernandez, Laura Hernandez, the program manager, I believe, will be providing that report.
Yes. Good morning, Dr. Borland. Good morning, board members. My name is Laura Hernandez with the licensing department. I provided some statistics for the behavior analyst and assistant behavior population. You'll see the full population numbers for fiscal year 2021, and then the numbers so far for the first quarter of 2021. A difference in these statistics in the last meeting, you had asked actually our customer service division about email contacts, because the way that those have been channeled are different now. Instead of going through customer service, they're sent directly to licensing team for those programs. For the month of January, and that's a manual process to get those numbers right now. So I provided the first month that we could, and hopefully we can have a better system to provide better numbers. But the number for January was 28 contacts, and those were just web contacts where they went to the TDLR website and contact us directly. And about 50% of those emails were regarding verification requests. They're wanting their verification of their license into other states. So that was about 50% of those emails we went through and looked through. Also in my report is our current project. In the last meeting, you were interested in statistics for the number of licensees that have not renewed their license. And we are currently working on that. This is the first year for renewal, and licensees have up to a year to renew. So we would probably be able to provide better numbers once after June 2021. That way we can see how many didn't renew. So once that comes up, we'll be able to provide you with some numbers for that request.
Thank you. And thank you very much for that additional information. I regret that has to be done manually at this point. And
yeah, no, it's no problem. It's a difference in process for all of us. But my team was able to provide those numbers, and so we're happy to provide those numbers.
thank you. And again, it's all the more, the situation is complicated because I know a lot of the work is being done away from the building there. So
Right.
it's harder to kind of go sit with somebody and say, help me figure this out. So appreciate the staff doing that, and appreciate you looking into the lost behavior analyst.
We'll look into it.
Yeah, that's all we can ask. Thank you. Any questions or comments from the other members of the board? If not, then moving ahead to the customer service division, Mr. Nguyen Nguyen, the program specialist, will be providing us that information. Please, sir.
Thank you. Good morning, advisory board members. My name is Tuan Nguyen. I'm customer service manager for this program. So as you can see, since the last time we met, we have a 0 count for emails, but our average every month for November, we had 45 contacts. December, we had 35 contacts, and January was 31, and those are all phone calls. As Laura just stated, all the emails, if they choose behavior analyst, it goes straight to Laura's team. So for the contacts that we did get through customer service, customers were asking about assistance with the website navigation, how to do the verification letter requests, and license that. Other than that, if you have any other questions for me, I'll be happy to answer them.
Thank you for that additional information. Other comments or questions, recommendations, or from the board members? again, it's,
Actually-
so if go ahead, please. Your name?
I actually, this is Amanda Nichols.
Mhm.
I actually had a question for the licensing division part of the presentation. Or the report.
Excuse me, Ms. Nichols, can we circle back to that? Let's finish this section.
Of course.
Okay, and then we'll go back to ask Ms. Hernandez.
Sure.
Okay, but feel free to ask something to Mr. Nguyen.
This is Stephanie Sokolowski. I have a question. Amanda, are you done? Are you finished, Amanda?
Yes, I am.
Okay. I do have a question. I was just noticing for December and January of this year, there were no emails. I just thought that was an interesting observation.
Yes.
Yeah.
So just as I stated before, on the web forms, if a customer selects behavioral analyst, they actually route it straight to Laura's team. So
Uh-huh.
if you look at the licensing division report, she is able to give a amount of contacts that is considered web contacts, and she has represented the January data in there so far.
Okay.
So those are now routed right to the licensing team
Ah.
to faster responses.
Okay. Just like you just said that, oh, well, never mind.
Okay.
Thanks.
Yeah, I was wondering similarly, Dr. Sokolowski, this is Gordon Borland. Sorry, I forgot my name. Because I was surprised, given here we are with everything being virtual, that you weren't emails. But so if I understand correctly, Mr. Nguyen, the department has received at least 28 emails, and wherever they ended up, looks like.
Yes.
Yeah. Okay. Not necessarily to customer service, but were routed elsewhere.
Yes.
That makes, you know, a lot more intuitive system that there would be some. So, but they just didn't go to customer service.
Correct. They usually, if they go to us, we normally route them to licensing, but now they go directly to licensing, so don't have to wait on us for the extra step. So it's a faster, efficient process.
This is Gordon Borland. Yeah, I think that getting faster responses for the public is a great move. We appreciate that. Other comments or observations regarding the customer service division report?
This is
Ms. Nichols.
Amanda Nichols. So I'm looking at the numbers and I see in September 2020 of the fiscal year 2020, the emails were up to 47. And it's dwindled since then down to 0 for the last couple of months. Did you guys change the system in some way?
Oh, yeah. So before, people would be able to see a industry email for our analysts, but instead we replaced all the links to use our general web form. And so if customers were using our general web form, which we made that, we made all the changes to all the forms and everything to where they would use the general web form to steer that traffic that way. And that way, if they were to use that, they would be able to contact directly with our licensing team for this program.
Excellent. That sounds good. Thanks.
Thank you. Any other comments or questions for Mr. Nguyen? Okay, thank you, Mr. Nguyen. Appreciate it. Appreciate what your folks are doing there. Wanted to circle back now. Ms. Nichols, I believe you had, upon further review, had a question or comment to, for, I guess it's for Ms. Hernandez for the licensing division.
Yes, I did. So I know this is the first year that we're able to, or that people are able to renew their license. Is there a way that, or I'm curious, do we have a system set up to ask individuals why they're not renewing? Like an email system going out reminding them, or just some kind of way to collect some feedback as to whether it's something that we can do on our end to make it easier for them to renew?
So we currently don't have any a system in place to ask them why they aren't renewing or if they're going to renew. We do send an email reminder about 65 days in advance saying, hey, your license is about to expire. If we don't receive anything, we do send another one at 30 days. And then at 15 days, then we send out a postcard that says, hey, don't forget, we'll send something by paper. Maybe the email was wrong or for whatever reason. So we try those avenues to just remind that, hey, it's ready to renew. But once the expiration date passes, we don't have anything in place to go back and and say, oh, your license is expired at this point. Do you still want to renew? At that point, we don't. I mean, the system is available for them to renew, but we don't send any other additional notifications after that, once the license's expiration date is passed.
Thank you.
Any other questions or comments for the licensing division, Ms. Hernandez, before we move past?
I've got a question. This is Stephanie Sokolowski. Ms. Hernandez, is that public information? Is the renewal public information? Because I would just be really curious to find a way to contact them, because I'm curious why they're not renewing.
So on our license search database, they do stay on the web. You're able to do a license search by program. So if you were to look for behavior analyst, and it will show up the expiration dates. You can search by who expires in, February 28th, and it'll show you a list. And they only stay out there though for about, I think it's 30 days after they expire. I believe I can get verification on that, but I believe it's 30 days. And then after that, then it doesn't show up anymore. The licensee wouldn't show up anymore.
And are they actually expunged from the system?
No. That information stays in our system.
Just not
because
public.
they have, right, but because they have 18 months to renew, so they can go in and so no, we never get rid of their information. We have that.
Okay. All right. Thank you.
You're welcome.
Any other questions or comments regarding the licensing committee? As my address. Hearing nothing else, then continuing through the staff report section, the third report is from the enforcement division. I think Ms. Cox will be providing that.
Yes, good morning. I'm Karen Cox, Senior Prosecutor with the Enforcement Division, and I will be giving your staff report this morning. First, we have some personnel updates. On November 6, 2020, Prosecutor Ken Sharp retired after 7 years of service with the agency and 13 years total service to the state of Texas. During his tenure at TDLR, Ken worked briefly on the transportation team. Most of his time, however, was on the criminal history review team, where he reviewed thousands of applications to see if the applicant's criminal records were serious enough to prevent them from getting licensed. Ken was the co-founder and original commander of the department's Veterans Association and was always very active in that group. On December 4th, 2020, Prosecutor Michael Shirk retired after 8 years of service with TDLR and nearly 2 decades with the state. Michael was a member of the transportation team and was enthusiastic for public service and for protecting the citizens of Texas. He served as a mentor for many of our attorneys on staff and left a legacy of public service that will be long remembered. 3 of our attorneys, Amanda Barrera, Arusa Nizami, Arusa was the one who gave the staff report at the last meeting, and Natalie Oliveira were promoted to Attorney 3 positions to fill the vacancies created by the retirements and promotions in the Enforcement Division. Amanda and Arusa's promotions were effective December 15th, 2020, and Natalie's effective on New Year's Day, 2021. On January 4th, 2021, Arthur Aravalo was hired to fill the investigation manager's position. Art retired from the Austin Police Department after 26 years of service. Since then, he worked for the Travis County Sheriff's Office and more recently served as a captain with the Texas State University Police Department. We look forward to his contribution to the success of our team as we continue to strengthen the Enforcement Division with staff that embraces our mission and shares our dedication to affect positively the citizens of Texas. Now let's get to some statistics. Shown below are the enforcement performance measures, the things that we report to the legislature, and key statistics for the Behavior Analyst program and for all TDLR programs combined through December 2020 of fiscal year 2021. This is the period beginning September 1 and continuing through the last available date, which was September 1st, 2020 through December 31st, 2020. We opened in that period 11 behavior analyst cases and closed 10 of them. The average time to close was 186 days. 60% were resolved within 6 months. None of them resulted in disciplinary action. And there were 33 cases pending at the end of December 2020. The source of cases open in this program for fiscal year 2021 were all either consumer complaints or criminal history evaluation letter, criminal history cases. Case outcomes, all 10 of these cases were closed and formally resolved. And you can see on the right a column that shows the TDLR numbers for the other programs: 10 commission orders, 228 defaults, 306 agreed orders, and then the penalties assessed, licenses revoked, and such for the other programs. Let's go to the next page. Behavior analyst closed and reasons through December 2020 for fiscal year 2021. Again, that's just September through December of 2020. 8 of them were closed for insufficient evidence. 1 was withdrawn by the complainant, and we issued 1 criminal history evaluation letter stating that the applicant was eligible to receive a license. 9, let's see, the behavior analyst alleged violations at opening. These are the summary statements of the violations when the case is opened in our intake section. 9 of them were code of ethics, 2 criminal history, and 1 for unlicensed activity. There were no violations resulting in disciplinary action for fiscal year 2021. Some additional statistics through the end of December 2020. The median age of the 33 pending cases at the end of December is 216 days. The oldest case has been open for 819 days and the newest for 38 days. Get a little bit of summary of some of the alleged code of ethics violations alleged at opening at the beginning of the case. There were 3 for inappropriate multiple relationships, 2 for physical abuse, 2 for sexual misconduct, 1 for practicing under the influence of drugs or alcohol, and 1 for record keeping, for a total of 9. Shown below are, now we get to fiscal 2020, fiscal year 2020. This is September 1, 2019 through August 31, 2020. There were 35 cases opened in this program, 10 closed. The average time to close is 98.9, so basically 99 days. 90% of them were resolved within 6 months. None resulted in disciplinary action, and we closed 30 cases at the end of fiscal year 2020. And for fiscal year 2020, all of the cases that we had in this program were consumer complaints. Its outcomes, which again shows 10 cases closed, informally resolved, and no license suspensions or orders or penalties collected. The violations alleged at opening in this program, there were 33 code of ethics violations, 2 unlicensed activity cases, and 1 for lax honesty, trustworthiness, and integrity. No violations resulted in disciplinary action in year 2020. The cases closed, 9 of them for insufficient evidence and 1 with a warning letter. And Dr. Borland had requested some additional information from us, and I can answer those questions right now. First of all, Dr. Borland had asked what was involved in the informal resolution of complaints noted in this report. Does informal resolution pertain to the 10 closed cases addressed at the top of page 3 of 5? Yes, all 10 are considered informal resolutions. Informal resolutions can be summarized as cases closed at a level below the executive director or with action by the commissioner, by the commission entirely. Dr. Borland would like to ask what is involved in evaluation letter eligible. We have a process for what is called a criminal history evaluation letter. This is when an applicant or someone who wants to apply can request that we review their criminal history if they have any. It is an expedited version of the ordinary criminal history evaluation that we do for every single applicant in the for all licenses the agency issues. Someone can send a letter, ask us to look at it. We will review their criminal history and issue a letter. If there are any issues, if they have a criminal history, then we'll look at them, see what we can find out. The vast majority of criminal history evaluation letters are closed like the one in this program for eligible, in which we think that their criminal history will not affect their ability to obtain a license. If there are issues which affect their ability to obtain a license, we will issue what's called an ineligible letter, ineligible, which outlines the relevant rules and statutes and why they affect the license and why that's implicated, why their criminal history implicates those. The applicant may still, even if they get a letter stating that they're ineligible, they can still apply, provide more evidence as to why we should issue a license. And if we still deny the application, they can then request a hearing and go to the State Office of Administrative Hearings through the typical process. The evaluation letter specifically refers to the expedited process if requested by the applicant, by someone who wants to apply before they do so. Let's see, and then what credentials were held by the person involved in the complaint regarding unlicensed activity? And what did this person engage in? And has the case been closed? What was the action taken? The department can't discuss complaints because they're considered super confidential under Texas Occupations Code 51.254C, which prohibits us from discussing or disclosing information about cases in certain programs, including this one.
This is Gordon Borland.
Question.
Excuse me, Gordon Borland here. So I want to make sure I understand. You're saying that that a complaint cannot be discussed.
We can't, during the pendency of a case.
Okay.
It's open. The provision says that we can't release any information to the public about it. We can discuss it with the respondent, and there's a process with litigation which we will go through and which proceeds normally. But all the documents relevant to that complaint and covered in that complaint are confidential by law and can't be discussed in a public forum other than, well, and even if we go to SOA, they're subject to confidentiality at that point. So,
Excuse me, Gordon Borland, STOA, make sure everyone understands, STOA would be what?
oh, I'm sorry. State Office of Administrative Hearings, SOA.
Yeah, SOA.
Yeah, there's some background noise here that's.
Yeah.
But
That's good. So one more question regarding this issue, and then I'll move on, or let you move on.
thank you.
So so can you tell us, has this complaint been resolved, or is this one of the still open complaints?
This case is still open.
Okay.
So I've got
Thank
a question.
Thank you.
Yes,
Uh,
ma'am.
Hey, Ms. Cox, I've got a question. Stephanie Sokolowski. So as a board member, and I understand the confidentiality requirement, how can we learn? How would we be able to learn so that we can do things that might be helpful regarding these kind of complaints or any complaint? If it's all confidential, how can we learn?
I have a presentation on that at the end of it. I want to encourage all of you to become expert witnesses, and this actually will tie into my answer to the next question. If you are a subject matter expert for the department, you would be able to help us with the case and learn about it. Other than being a subject matter expert in this, there really isn't a method to get involved, but we really need subject matter experts in this case. So if you will get involved as a subject matter expert, you would find out the details of these cases.
Okay. And this is Stephanie Sokolowski again. I was really thinking in terms of, as a board member, what can we as a board think through about how we can make improvements, maybe through recommending rules or guidance. So it wasn't that I'm just too curious about this guy and I want to know what he's doing. It wasn't that. It wasn't a curiosity. It was, how can we as a board affect change, meaningful change, if we don't have information? And I understand that's just the way it is. But
I think that your actions as a board in recommending rules and keeping involved in the industry in general will do much more than any individual case would. Once the cases are closed, or if they go to hearing and there's a proposal for decision issued, if you read those, that would be one way. But your actions as a board in keeping involved with the industry and recommending rules and policy changes is as important as any individual case would be.
Okay.
So proceeding with what you're doing is very helpful.
Okay, and this is Stephanie Sokolowski again. I'm not really highly curious about one case. I'm concerned about trends, but that's okay. I get it. And I get that, you know, we're writing policy and rules, and that's how we can affect change. Okay, thank you. I'll be quiet.
Yep, this is Gordon.
Dr. Sokolowski.
Yep.
I'm sorry, Dr. Borland, may I address Dr. Sokolowski's question as well? This is Christina Kaiser. I'm Deputy Executive Director for Regulatory Services and formerly the Director of Enforcement for the agency for quite a few years. I would add also that your role on the advisory board in terms of making recommendations for the enforcement plan and for the criminal conviction guidelines, those are two critical policy documents that guide the work that the enforcement division does. And so that is a place where you definitely have an impact on the outcomes of enforcement cases. And I will tell you that going forward, there will be similar work for the advisory boards to do as a result of our sunset review. And I'll talk a little more about that during the executive office report, but that will involve helping the enforcement division determine priorities for complaints. In other words, if we have 9 pending complaints, which ones present violations that are the most important or the most critical in terms of protection of the public. So that's a new policy that we'll be developing in the coming months or possibly year.
And this is Stephanie Sokolowski. I'll make one more comment. Thank you, Ms. Kaiser. I guess what we need to know is where are the gaps, just like you just said, with enforcement, where are the gaps? Where, you know, what are the cracks that we need to fill? But you'll advise us about that as you're reviewing as cases move forward. So, okay, thank you.
Thank the Gordon Borland. Thank you, Dr. Sokolowski and Ms. Kaiser. And I just share, candor, I share Dr. Sokolowski's concerns. And I similarly point out that my concern is not prurient regarding any one specific case. It's the trends in what's happening. That's so. I am concerned. I will just be clear. I am concerned that over time, so far as a licensed profession in Texas, behavior and analysis is young. We just, our first renewals. But I'm concerned if there's going to be trends emerging, and frankly, and I know Ms. Cox is going to address this momentarily, I'm concerned about what's happening with those long-standing not yet closed cases. One is over 2 years. And I know you're going to come back to that, but I want on the record to say I am concerned about this and how the advisory board can help with this, because I also understand the importance, absolutely understand the importance of subject matter experts, but all board members will not be subject matter experts on the same. If we were all subject matter experts, let me put it that way, we would not all have access to the information. Just in a particular case or cases, it would only be those board members who are subject matter experts on those cases. And subject matter experts are not necessarily board members. So those non-board members who are subject matter experts can't talk to us about it. So I'm concerned that we have the potential for an information gap here, as Dr. Sokolowski said, that would be helpful for us in terms of advising where new regulation revisions or new additions might be needed. I realize that right now maybe there's nothing that can be done about that, but I do want to second and emphasize Dr. Sokolowski's concerns, because I think it's exceedingly important that the public and our profession be confident in us that and in the operation here with respect to complaints and ethical complaints, because I happen to know, and this was outside of activities of the board, that people, my activities outside the board, I happen to know that in fact there has been another members of another profession who have raised a related issue, and we're kind of, it's difficult to address that. So that's my soapbox, and I'll jump off. Ms. Snyder, please.
Lori Snyder here. I wanted to add to that on the alleged code of ethics under the inappropriate multiple relationships, we had a lot of discussion when we were developing the rules and the writing of that particular section. And one of the things as a mother of a consumer that I had noticed in our original writing of it was looking at parents that might make complaints, not fully understanding the wording that we wrote in there. And I felt that we had revisited to make it clear what that looks like, because the original writing had stated that multiple relationships, meaning you couldn't have two BCBAs working. And my child growing up, he's 20 now, since he was 2, in the school district, he might have a BCBA working with him. Then we may be running a private ABA program, and then we may also have a BCBA and a social skills program. And so I was just curious, with that being the higher number of 3 in maybe that consumers might not understand the wording that we finalized in that.
Ms. Snyder, is that your question about consumers not understanding without discussing specific cases, which kind of restricts what I can say.
Right.
But again, part of the reason that we get subject matter experts is to help us just get into the more details of each specific case and each specific set of as you said, inappropriate relationships, and discuss why this would be inappropriate or not, and to help us understand those cases.
Well, maybe this will work.
And with that, Dr. Borland, you had said in your questions, one of them was, why does cases take so long to resolve? And I can tell you that almost exclusively it's the lack of subject matter experts in this program. We have 1 behavior analyst qualified subject matter expert. By comparison, we have 9 qualified, we have 9 podiatrists that we can refer cases to, and 5 midwives. When I discussed the training of a little bit about training at the end of the meeting for experts, one of the issues that we run into is a conflict of interest. If our 1 subject matter expert in this program knows any of the participants in a complaint, that person can't review the case. So that case is going to sit until we can get someone to help us. And that by itself accounts for most of the age of these cases. And again, the last question was, what is the nature of the complaint?
Excuse me, Gordon Borland. I'm sorry. Thank you for that additional information. I just pointing out from my own perspective, I am amazed and surprised and concerned that there's only 1 subject matter expert now. I know we've had some move out of the state, so I want to be clear. It's not that we only had 1 ever, but that's all we got now.
Right. It's only 1. We have 1 right now.
Yeah. And I also want to be clear that the midwife subject matter experts aren't consulting on behavior analysis.
No. Clear about that. I am comparing health-related programs that in other programs, we have more people that help us in cases in those programs.
Yes, I understand. So the podiatrists won't be subject matter experts for behavior analysis cases either. I fully understand that, but knowing how sometimes people maybe watching online or later are perhaps multitasking and thinking, what the hell is going on here? So I just wanted to be clear on that. And I think you'll give us some information later that'll be really helpful in terms of the subject matter expert. I'm just going to say now, though, I've looked into it and tried twice and decided this is such a tedious affair. I'll just have to come back to it. So I hope that you will be able to reassure me that it has been streamlined, but that's for later. So thank you for all this information so far. Please continue. I think you had another issue. There's something else there.
Just the last one was you had asked about some of the other cases. And again, that's covered by confidentiality provisions that we can't really discuss the open cases. So are there any other questions I can answer at this point?
This is Amanda Nichols. So you said that we only have one subject matter expert. How long have, I mean, these cases are very old. So, I mean, this seems to be a trend. Have we had, I mean, on average, how many subject matter experts have we had?
I don't have exact details on the number that we've had for the entirety of the program, but I can pretty confidently state I don't think we've ever had more than 2 at once.
Okay.
So we have always had a severe paucity of experts in this program.
Is there a way to prioritize this? I mean, you did say that you were trying to streamline the training, which is great, but I mean, as a consumer, I would be very frustrated if I sent in a complaint and it took over 2 years for this to be addressed.
I completely understand. And one of the issues, of course, is that there's only so much streamlining we can do, because one of the most important things about being an expert is that they have the qualifications and knowledge necessary to be experts in the first place. So, and there's some training that we have to go through to make them understand what our enforcement process and what it's like to be, they have to be a witness. So we do the most that we can, but there is a point on which we can't eliminate anything to make it easier that doesn't then reduce their effectiveness and credibility as an expert. So
Well, and
it's a complicated process.
Sure. And I appreciate all the work that you guys have done. I don't want to diminish any of that. I just see this as a very troublesome issue that needs to be addressed sooner rather than later. So, and yeah, we want to do everything that we can to make this easier. That's why we're here, to make change on this end so that people have faith in the system. So anything that we can do, let us know. I would be more than happy to do the training, but I mean, we need to get more people in on this as soon as possible.
This is Gordon Borland. Thank you, Ms. Nichols. I certainly understand. I think I've already expressed how my concerns here. I am glad that this issue is getting light shined on it today. So thank you very much, Ms. Cox. I really appreciate that. If we could all go back and do something differently, I guess, kind of like dealing with the electrical grid in Texas, there's things we might do differently about how we might prepare.
Yeah.
But here we are today, and we move forward. We look through the windshield, not the rearview mirror. So thank you. And I second Ms. Nichols' comments that we certainly appreciate what you guys are doing, and we know that it has been made all the more difficult and complicated because of everything having to be done online. What an added challenge on top of everything else. So we appreciate your work.
Thank you, sir.
Other comments are regarding Ms. Cox's presentation? Sloan.
Yes. Is there anything that we, as just the general public, can do to help recruit subject matter experts? Who are you looking for exactly?
We'll go into that a little bit at the end of the presentation. At the end.
Thank you.
Thank you, Ms. Sloan. Excellent question. And I'll just say, Carol, this is maybe kind of getting ahead of things, but and Ms. Cox may know this, but the Texaba Public Policy Group has provided information encouraging, advising people, behavior analysts in Texas, of the need for subject matter experts and requesting that people initiate the process to become so involved. So maybe, and for Ms. Nichols, maybe there's a little flicker of light out there, maybe, we hope. But we'll all be better informed here before the meeting's over. And
Thank you, sir. Yes.
Ms. Snyder, did you have a comment? Yeah. No. Okay. Well, Ms. Cox, I want to back up for a minute because, again, I want to be clear. We're not trying to in any way say anything derogatory about what the work that the folks you guys are doing. It's so important. I mean, that's part of why licensure is important, because it protects the public through enforcement actions. We hope prevention, but if need be, you know, there's only so many carrots, I guess. Sometimes you have to bring out the enforcement stick, as it were. But I want to back up and say, just acknowledge appreciation for Mr. Sharp and Mr. Shirk, who put so much time in it, even though they may not have had a lot of input into our program. It's all for the public. And that's certainly with the enforcement, the criminal background checks, that's certainly relevant. And for the 3 incoming people who have moved into new positions, I mean, we're pleased that they're part of the team and look forward to all the good that they will be doing, as well as including Mr. Arvalo. I mean, you got to keep moving, and appreciate what you guys are doing. So thank you.
Yes. Thank you very much, sir. With that, appreciate it. Very good. Thank you.
And appreciate your addressing those issues I'd raised. Any other questions for Ms. Cox on this report, on the staff report issue? If not, we'll move on to item 4 under staff reports, the regulatory program management. Ms. Bryce, Katie Bryce, will be presenting that report.
Good morning. I am Katie Bryce. I'm program specialist with the medical and health professions section of regulatory program management. We also have some personnel updates. Our section has 2 new staff members, Angela Sanders and Sean O'Neill. Both joined our section on February 1st, 2021. Angela has worked for TDLR since 2017, and Sean has been with TDLR since 2005. And we are happy to welcome them to our team. Our current projects are facilitating the education and examination work group meeting to review and discuss House Bill 2059 from the 86th regular session, which requires licensees to take an approved human trafficking prevention training course for license renewal. The work group reviewed information to make a recommendation, and we'll be going over that later on in the meeting. The TDLR Health Occupations Annual Report was submitted to the chairs of the House Licensing and Administrative Procedures Committee, House Public Health Committee, Senate Business and Commerce Committee, and Senate Health and Human Services Committee on February 1st. The report is statutorily required and contains programmatic license and complaint data. And the report was emailed to advisory board members earlier in February. It's also available on the TDLR webpage under agency reports. We have been working on rule review projects for 6 of the medical and health profession programs. This rule review happens every 4 years. So we'll be doing it for this program in about 2 more years. But you're not currently being reviewed. We've also been working on draft emergency rules to be enacted if a disaster declaration is issued from the governor's office in the future. We've been reviewing bills filed by the Texas legislature, and also we have on our website bill tracking information for licensees to go and look. They're sorted by licensing profession, and so you can go and see if there's anything related to you, behavior analysts, that interests you. There are quite a few on the webpage for behavior analysts. We've also been involved in the development of our new licensing system. Dr. Borland, you had asked about an update on this in our last meeting, and currently I still did not have any projected timeline for when this new program will go into effect. I know we're probably going to be putting some of the larger programs in it first, just
Sure.
to try to roll it out that way, but I don't have an updated time frame on that. For outreach, I got to attend the virtual Texas Association for Behavior Analysts Conference, which was held February 11th through 14th, and really enjoyed sitting in on some of those sessions. And I did want to mention that we put out our newsletter. I believe it went out in February or January. And in that newsletter, we did have an article on the process to become an SME, a subject matter expert, just to try to get more people aware of the need for it and put it out there. Thank you.
Thank you, Ms. Price. It's Gordon Borland. Any questions or comments, observations related to the staff report on the Regulatory Program Management Division? Well, I want to thank you for the report, first of all, and all the work you guys are doing, and for addressing question we had about the licensing program. And also, I think it's really beneficial that people who are watching now or asynchronously are aware now that there is this information on the website regarding bills filed that might pertain to behavior analysis. I think it's really helpful information, so people need to can look at that at their leisure, and see if there's things they think should be addressed. They should engage with which they should engage. So I think that's a really important feature. So thank you very much.
I'd like to point out that it's not necessarily bills that impact your behavior analyst license, but it could be something that impacts behavior analysts in the provision of services to students in schools, or billing, or any number of things. It's just as far as it relates to behavior analysts.
Gordon Borland, and thank you, Ms. Bryce. It's even better because it's so hard to find all the needles in the legislative bill haystack. I mean, it's an incredible number I know already. It's really hard to track. I mean, even when you do the search by certain terminology, it turns out. So thank you. Again, glad to hear of the new staff members. Look forward to productively working with them as we have everyone else in your division as well. Any other questions or comments, observations for Ms. Bryce at this time?
This is Amanda Nichols. Everything that Gordon just said. Really looking forward to the working with all the personnel and everything. Also, I just want to say that it is relieving to hear that the subject matter expert issue is being addressed by multiple departments. It's not just a burden for the enforcement division. So that's really good, because I think that's how we are going to be able to succeed in this, in getting more SMEs.
Right. We definitely want to get the word out however we can.
Yes.
My only observation is that I look like I am kind of floating here because my hair keeps coming in and out of this screen. Sorry about that.
Very angelic. You look
Gordon Borland, thank you, Ms. Bryce. I commented earlier how much fun people can have with virtual backgrounds. Right. And thank you for illustrating that for us. Thank you again for the report. Any other comments before we move? The next staff report is from the Executive Division. Ms. Kaiser, Christina Kaiser, Deputy Executive Director, will be providing that report. Can't hear you.
Christina, you're muted.
That was fun lip reading
I was really
assessment.
going too.
I
Good
didn't do
morning.
well.
Good morning again, Mr. Chairman and advisory board members. I am Christina Kaiser. I'm one of the deputy executive directors here at TDLR. My area of responsibility is regulatory services, and that includes the enforcement division, the regulatory program management division, and the field inspections division, which doesn't have a touch on your profession. And I will be providing the executive office report today. One of the things I wanted to talk about is the agency's response to the COVID-19 pandemic. As you might suspect, this has been an exercise in complex problem solving. This is an environment that changes daily. Our knowledge changes daily. And so we have very much been learning as we go and figuring out as we go along what our response should be. Overall, I will say that safety has been our top priority, not only for our employees, but also for our licensees and for the public who we serve. Our response has been in two parts. There's been an inward-looking response that relates to our staff, and then an outward-looking response that relates to our licensees and to the public. I'll talk a little about the staff level response first. In March of 2020, almost a year ago, when the pandemic became critical, we began a work from home initiative for those employees whose work allows them to perform it remotely. We do still have a staff presence in the office for the work that has to be done on scene. We have limited the staff presence in the office as much as we can, and we have taken safety steps to keep people isolated from one another as much as we can, rotating schedules, keeping appropriate spacing, requiring masks and other safety protocols to keep people as safe as we can. A few other things about our staff level response. We did stop all field activities at the same time last year in March. We did restart those in June on a reduced basis, again, with safety protocols in place. And we are continuing, since then, we have continued to increase and increase and increase a little at a time the field activities that we're comfortable with folks doing. And this includes things like investigations and inspections. Increasing those at a little at a time with assurances about safety measures. We did stop all non-essential travel, and that included things like going to conferences or to speaking engagements. And as you're very aware, we did cancel all in-person public meetings, including commission meetings and advisory board meetings. We have been finding our way over the last year with holding public meetings through these online platforms. And I believe today makes number 34 of the advisory board meetings that have been held in an online setting. And I believe we've held at least 8 commission meetings in an online setting. And in each one, we have learned a little something new. In terms of our outward-looking response for our regulated industries, we have primarily tried to be a conduit for our licensees, following developments and keeping them informed about things like orders issued by the governor or orders issued by local jurisdictions that relate to their profession. We have created a space, we did a long time ago, create a space on our website to share information about developments, and actually on your individual site for your specific profession on the website, you will find information about COVID response matters that were specific to your profession. That included some of the regulatory relief items for which we sought approval from the governor. Some of those were for limited periods of time. They included things like continuing education waivers for a certain period of time, extending expiration dates for certain licenses, suspending certain inspection requirements, and the like. Today, I will say that we are still very much in that same place. We are still navigating the pandemic to the best of our ability based on the knowledge that we have right now. And we will continue to do that until we get into a more comfortable place. Another item that I wanted to report about is the agency's sunset review. At your last meeting, you probably received a briefing on this as well. TDLR's is currently under review by the Sunset Commission. Our review began around September of 2019. The point of a sunset review, of course, is to determine if the agency is still relevant, or are we still adding value in terms of the purposes for which the agency was originally created. So the sunset staff issued their report with their recommendations in June of last year, June 2020. The report contains two types of recommendations, those for statute changes and those for management actions. Management actions are things that the agency can do on its own initiative without waiting for the legislature to do something. Some of the more recent events in December, the Sunset Commission, the full agency, held a public hearing about TDLR's Sunset Report. And then in January of this year, the Sunset Commission held a decision hearing where they actually voted on the recommendations that were offered by their staff following their review of the agency. Of note, on issue 1, the Sunset Commission did vote in favor of continuing TDLR in existence for 12 more years. We're very excited about that. And then if you have had a chance to review the report, you'll see that it contains 7 issues, including things like recommendations to deregulate certain programs, consolidation of the barbering and cosmetology programs, and then some other recommendations that are specific to certain programs. One that is of interest to me and that I touched on a little bit earlier is issue 6. Sunset has recommended that we take more of a data-driven, risk-based approach to our regulatory functions, and that includes inspections and enforcement. Sort of relevant to the discussion earlier in the meeting, one of the recommendations is that for the enforcement process that we adopt a prioritization process for complaints, recognizing that as a regulatory agency of the state, we have limited resources. The thinking is that all complaints are not created equal and all complaints are not deserving of the same level of priority. And so this prioritization process would allow us to determine which ones rise to the top and receive attention most expeditiously. Now, at the other end of that spectrum, that might mean there are some complaints that we determine we're not going to investigate or not going to pursue. And that's just part of a data-driven or a risk-driven process. And I think that's a perfectly acceptable outcome. So I mentioned there are different types of recommendations in the Sunset Report. There are management actions and there are statute recommendations. So after the Sunset Commission voted in January to adopt certain recommendations, the thing that happens next is a bill is created, which contains all the recommendations for statute change that the Sunset Commission adopted. And then that bill has to make its way through the legislative session. And of course, the legislature is in session right now. As of yesterday, our Sunset bill had not been filed yet, but we understand that it is in the works right now. So we should see that shortly. And I'll just say, in closing, relating to the Sunset process, this has been a very good process for TDLR. You know, we take pride in ourselves as an agency that we are experts in regulation and we are experts in licensing in those processes. But it is always critical to have someone from the outside who's not, you know, part of our organization to shine a light on us as well and take a look and show us where they see gaps. And so no matter what happens with the Sunset bill, we are a better organization already for having gone through this process. And I can tell you on the management action recommendations, we are moving forward with those already and making some really good progress. I'd also like to just speak briefly about the, excuse me, I'm moving around here, about the legislative session. Some of the reports that came before me already touched on the legislative session a little bit. The session is underway. It began in January and it runs through the end of May. TDLR is currently tracking 180 bills that relate to us as an organization or relate to the professions and industries that we regulate. I believe Katie already mentioned this. Bills that are of interest to our licensees are listed and available on the TDLR website. On the main page of the website, there's a square right in the middle with a picture of the Capitol. You can't miss it. And if you click there, they're listed, and they are actually organized according to topic. And so you can scroll down and find a category of bills that we believe anyway are of interest to your profession. Currently, some of the big events that are happening are that the Senate Finance Committee and the House Committee on Appropriations are both holding hearings about agencies' budget requests. Next week will be a big week for us. We're going over to speak before Senate Finance on Tuesday, and then House Appropriations on Wednesday. So we'll have a lot. We'll have a lot going on next week. And then, of course, as I said, the legislative session runs through May, and so there will be a lot more action still to come after this, but the budget is the big topic of the moment. The last thing I wanted to cover with you are some statistics related to the public and your licensees connecting with TDLR's website for your profession. And Delia has put those up on the screen. Are you able to see those?
Yes.
Okay. So this, we like to let our advisory boards know about the extent to which your specific website has been has been viewed by the public and licensees. So over the past 6 months, from August to February, your website has had over 19,000 views for an average of 104 per day. 61% of those folks who visited your site used a desktop computer to do that. 38% did so with a smartphone and 1% with a tablet. And the top reasons for visiting your site are listed there. License application, and actually the advisory board is number 4 out of 5. That's kind of interesting. That concludes my report. I'm happy to answer any questions if you have them.
Gordon Borland, questions or comments, observations from the board for Ms. Kaiser?
This is Amanda Nichols. I'm really excited for your next week. That should be a lot of fun. Talking to the finance committee and everything. Is there anything we can do to help out with that?
Not to my knowledge. We have our executive director and one of the other deputy executive directors and our finance person are in line to go over and offer that testimony and answer questions over there. I think these are hearings where they're having all the agencies, kind of stacked up one after another. And so I think their presentation will have a limited time.
Yeah.
So I think we're good.
Okay, well, just let us know if we need to call our representatives and help you out there. More than happy to do that. As for the data-driven prioritization process, I'm really excited about that too. That's a fantastic move. And then you also mentioned that the bills are all available on the website. That's also fantastic. I'm very interested to see the sunset bill populate there. Is there like a timeline? Do you think that's going to happen in the next, I don't know, month or?
It would be difficult for me to say. I know that the sunset bill is being worked on, but we're not the only agency who underwent sunset review. And so those are the sunset bills have already started being published. I think there have been 4 that have been filed already. And TDLR's is somewhere in that line. But how quickly it'll be filed, I don't know. There is a bill filing deadline, an absolute bill filing deadline. And I'm sorry, I don't know the date of it. I believe it's in March.
Yeah, it's coming up. It is coming. I can't remember the specific date either, but it is coming up. So I'm looking forward to seeing that bill. Great work.
Thank you.
Gordon Borland, other comments, observations, questions? Yes, Dr. Sokolowski.
So, Ms. Kaiser, congratulations on getting a recommendation that we should continue TDLR.
Right.
That's always a question. I've worked with other agencies and you just cross your fingers and hope you're going to be here next week. So congratulations. And I know it's really hard work to get through a sunset review. So, you know, take a breath that it's almost done. Thank you. Thanks for your
Thank you.
work.
Thank you.
Gordon Borland, other, excuse me, other comments or any questions from the board? Again, I want to thank you, Ms. Kaiser, for all this work, for the report, the work. And I just second previous comments about the what I consider successful outcome of the sunset review. It's and I know, like as Dr. Sokolowski says, you can't take that for granted. There's a lot of stakeholders involved and a lot of priorities, and you just, you know, don't take those for granted. So that's good news. I'm glad. And I similarly interested to hear about the data-driven prioritization of complaint handling. I think that kind of certainly merges with some of the questions we were addressing earlier. So that's all good news. And so one question, the budget hearings next week, the House and Senate budget hearings, those are not about a bill, but the agency has submitted its legislative appropriation request, and that's what they're reviewing at those meetings. Is that correct?
Yes.
It's just the financial stuff, which of course has programmatic implications, of course.
Right.
Yeah, I just want to be clear. Those are separate things from the sunset bill, which is crucial, and the legislative appropriations request, the money.
Exactly.
Yes.
I did get a notice pop up from one of our government relations people who was listening to the meeting, and the bill filing deadline is March the 12th. So thank you, Jeff Kopus, for listening and sending me that information.
Yes, thank you, Gordon Borland here. Yeah, I like Ms. Nichols. I wasn't remembering. I know I've seen it however many times, and just that was one of those my eyes glazed over moments, I think. Yeah. So any other questions or comments for Ms. Kaiser regarding the executive office report? Hearing nothing, thank you very much. And we're all, I think, glad to hear the good news. So
thank you.
And thank you for the report. Next item on the agenda is the a presentation of the, oh, excuse me, Ms. Sloan.
Yes, could I circle back 1 minute? I may have missed this, but when we were talking about the licensing renewal statistics, I wanted to make sure it was noted that the license has to be renewed every 2 years. So if you're seeing a big number in 2020, it was because that was when everybody it just began in 2018. And so the majority of the renewals probably would occur in 2020, and 2021's number would likely be lower. Am I correct in that?
I don't know the answer to that. If our licensing person is still in the meeting, I'm sure they can speak to that.
Okay, that would have been.
Yes. Hi,
That's Laura.
Hi, it's Laura Hernandez again. Yes, you are correct. This was the first set of renewals, so that's why we didn't have any statistics yet, because we want to give them that year that they have to renew, and then at that point we can see how that population is going up, going down based on the renewals. So yes, that is correct.
Thank you.
Gordon Borland, thank you. Okay, well, let's move to item F, the Enforcement Division presentation by Ms. Fox from the Enforcement Division on the process of becoming a now very hot item subject matter expert.
Thank you, Dr. Borland.
Yes.
And my able assistant, Chris Rossi, is going to do the screen sharing for me today. This is the excitingly titled Subject Matter Experts and Their Role in TDLR Enforcement Cases. Chris, can we have the first slide? This is from the Texas Rules of Evidence, which defines what an expert witness is. And it's a person who is qualified by, notice the bolded words, knowledge, skill, experience, training, or education. These are people who have additional knowledge above and beyond fact witnesses. There are two kinds of witnesses in a trial, the fact witnesses and the experts. Experts can give testimony in the form of an opinion if it would help, if that scientific, technical, or specialized knowledge will help the trier of fact understand the evidence to determine the fact and evidence.
in some of our programs, we need additional evidence from people who have special qualifications. Experts have, of course, the rules of evidence apply in trials. Experts in PDLR have a broader role than specifically testifying in a hearing. And in fact, very few of them ever get to the point of testifying in hearing. Most experts come in through this occupation code provision, which allows us to contract with a qualified individual, including an advisory board member, to assist the department in reviewing or investigating cases. And they can participate in an informal conference. The biggest thing that we need experts to do down here is evaluate evidence in a complaint and offer an expert opinion on a technical guidance on these alleged violations. To refer back to my earlier report, one of the rules that we discussed was inappropriate multiple relationships. If we get a complaint, we would need an expert to give us advice on these inappropriate multiple relationships. The department can't really adopt rules prohibiting every single possible bad relationship because there are millions of these. So we adopt a rule prohibiting it, and we have experts tell us which fact situation fall within that. Next slide. Important thing to remember is that if you become an expert, we have a statute that protects experts from lawsuits other than fraud or conspiracy or malice from any suit for damages from an act arising from the performance of those duties listed as informal conference or evaluating evidence in one of our cases. So you can safely be an expert and not be sued for liability from that. Next slide. How do we choose experts? We have both advisory board members. We can contract with outside people. First thing we do is all of our potential experts, both advisory boards and board members and people from outside the advisory board, are required to complete a questionnaire and return it. I want to discuss this questionnaire for a minute. It does involve a lot of questions, but refer back to the beginning where if you're an expert, you have special knowledge. We have to be able to make sure that each person we accept as an expert has that special knowledge, and we need to know what it is, and we'll be asked to provide it if it ever does get to a hearing. Experts are, as I said, a special class of witness that provide a special type of evidence. There are a couple of Supreme Court cases, and I'm not going to go into detail here, but I want to emphasize something. An unqualified expert, if an expert gives testimony that isn't qualified or isn't based on good supporting evidence, it's not merely that expert testimony isn't as persuasive or isn't as credible as other evidence. It's not evidence at all. So if our case is based on the testimony of an expert, a subject matter expert, and the opposing side can go through and can attack that person's qualifications, that eliminates our case. There's serious legal consequences if we fail to get someone who's qualified. So we do ask that each potential expert complete a questionnaire. And I have a slide later on that has a sample question. Then the next thing is we screen every potential expert to see if they have a history of enforcement history. Because if you have a history of complaints, that affects your credibility as an expert. And again, an unqualified expert opinion is not evidence at all. So next slide. Advisory board members. As we said, advisory board members have been selected and appointed by the governor because you have an unusual expertise in this field and your interest in maintaining the integrity of the profession. That makes you really good experts. One qualification, advisory board members cannot receive any extra compensation for their services as expert witnesses. So there's a couple of reasons. One, we like this because you're already getting compensation as advisory board members. There's not any extra. But also you do have special expertise. Yes, Dr. Borland.
Dr. Gordon Borland here. I thought I heard you say that we're already being compensated for being board members. I was Could you?
I don't,
expand on
yeah,
that?
it's,
I wasn't
I'm
aware of that.
sorry. I misspoke. It's that, but we can't give you extra compensation, put it that way. So then to the next slide.
Gordon Borland. Thank you. I was just wondering if I missed the check in the mail.
So contract experts. We contract industry organizations. We ask for recommendations. Like Katie discussed early in her presentation, we get them to recommend people to us. Then for contract experts, after we've screened them for qualifications, then the finance division in our agency has to do further screening because the state of Texas imposes certain contracting requirements, like have a tax ID number, and there's some others. Only after the potential expert has passed all these screens, then do we issue a contract to them. Next, and this is an example of the questions that we ask, and we want to know all your degrees, the name of the institution when you received it, major and minor field of study if it's applicable, all professional licenses, some other things we ask if you have any publications. And I want to discuss this a minute because within health professions, sometimes experts have subspecialties. In podiatry, we have a couple of people who have gone above and beyond the standard qualifications as a podiatrist to become experts in problems with the diabetic foot. They provide additional information, and if we have a case involving someone with diabetes, with diabetic peripheral neuropathy, then that expert can provide additional, more persuasive evidence. So we want to know those things as well. This is an example of that, of the questionnaire we ask. Next slide. After the screening has been completed and the expert's been contracted, or the advisory board has submitted the information, then we have a short training about the enforcement process and their role in each specific case. And that lasts about an hour, and we do it via teleconference. Before you're assigned any specific case as an expert, you'll get yet another screening to see if you have any conflicts of interest with any of the participants in the case. Someone who is related to one of the participants would be biased in that person's favor, or if you've had some conflicts in the past, we want to know that because that affects your credibility. After all that's been completed and documented, then we send the information collected by the investigator by secure methods, and we ask the expert to write a report based on that information. So next. And that concludes my presentation. As we say, we can't complete our mission of protecting the law-abiding citizens, hardworking members of your profession and the citizens of Texas without your assistance. May I answer any questions?
This is Amanda Nichols. How long does this process usually take on average?
A couple weeks, and then scheduling you for the training. The finance division is probably the longest one, but once that part is, if you're an outside contractor, if you're an advisory board member, it takes for the amount of time necessary for us to get the initial questionnaire back, review it, and then schedule you for training. So, like I said, that would be a couple of weeks. The training itself takes an hour.
Yeah. Okay. What does the finance screening include?
Oh, that is for non-advisory board members. That's for members outside contract experts.
Sure.
And that involves screening to make sure that you meet all of the qualifications set by state law that applies to all state agencies that hire experts.
Okay. So it's a universal screening. It's something, it's a standard that everybody must meet.
Yes, everyone who sells anything to the state of Texas has to complete that.
Okay. Thank you. This is Amanda Nichols again. Where do you find the application for this?
I can send it to you. I don't think it's posted online. I might defer that to Katie and some of our website experts to see if it's available that way. But we have the new, as Katie discussed, we have the new email online for that experts can contact us. And if you contact us through that, then we can send you the information necessary.
Okay, I'm sorry, I'm missing something really quick. So this information or this application is usually sent to you by somebody who you've been able to contact over the phone or something at the department? Is that kind of how the public
That
has
is
access to that?
that is one way. I mean, the new portal that we have online is very new. So we haven't had a chance to use it very much yet. But if you contact us through what Katie discussed or through any of the advisory board member people in the executive staff, they can get you in contact with someone who can send you that questionnaire.
I see. So if I have somebody that I want to direct to become one of these experts, would I tell them to call you, or is there an easier way for people to access this?
I
We do
can talk real quick if that helps. So in our last newsletter, there is a link to the web form to be able to get the subject matter expert application. And I can give the email address. It's kind of long. I don't know that it would help much to read it out loud, but we could have it maybe put up on the different program web pages so that there's a link directly on the web pages for it. Basically, it's a web form on TDLR that's called the Expert Witness Application. And on this web form, you put in your first name, your last name, your email address. You select which program you're wanting to be a subject matter expert for. And then you say whether you are an advisory board member or a subject matter expert. You give a brief description of qualifications, just real brief, like, I've been licensed since 2010 or something like that. You submit this form, and then the enforcement division will provide the application to you to fill out.
I think I just want to make sure that it's as available as possible. I understand that there's a screening process and all of that's going to be really important, but as like we said, it is pretty important that we start getting people at least started through this process so that we can take care of those pending cases.
Right.
So making sure that that information is available to the public would be a really good step in that direction.
Yes, our newsletter is available off of this program webpage. If you scroll down from the front page, it has the newsletter, and in the newsletter is the link to the web form. But we can also put up a more specific little news blurb on this page so that people can go directly to that.
That's perfect.
I
That's
can
really
ask
good.
our web administrator to do that.
Yeah, thank you.
Gordon Borland, other comments or questions or observations from the board? This is a prime opportunity. Hearing nobody else, I had a couple of observations and questions. I know that's a real surprise. First of all, just as a matter of, I guess, disclosure, I've been a member of this board since it was established, as have some of the other board members. And I got to tell you, I didn't know that such a thing existed for quite a while. So I think that what we're doing today is very important. I subsequently somehow heard about it and then sent an email or something, and I was then sent the link for the application. I've done that twice now. I've started and given up twice. Just this is feedback for you guys, not a criticism, just feedback. Because if you're someone who's been in the field for a while, like some old geezers like me, and you've been active in the field, Dr. Sokolowski just owned herself there. And you're doing presentations and you're doing publications. Actually, it sounds simple, but it is not. Pour all that information into the application. I guess I got to tell you. And now maybe it's because I'm just not very savvy about digital communication, but I can navigate most things okay. But I have now twice started this process and just said, this is going to take me a while to get all those presentations, publications, and also to ask about previous experience as an expert witness. And at some point, and it may have been revised since then, we were supposed to provide information about every case in which we'd been an expert witness. Now, in a former life, I did a lot of court-ordered evaluations and testified in court. I have no clue all those things, and I have no way now to recapture that. Now, I think there's now a time limit, I think, Ms. Cox, that's only looks back so far. But I'm just telling you, that was one of the things. So I think part of the problem here is one, as I think Ms. Nichols and others have pointed out, first of all, a lot of people didn't know. Secondly, there's a lot of response effort to get access to it in terms of, I got to actually search out and hunt this sucker down about how to even apply. Then once I get the application, if you've been particularly active in the field, which is good in terms of being an expert from the departments, but on the other hand, the response effort to actually enter that is considerable. And as we know as behavior analysts, and just commonsensically, that's a deterrent for some things. So I would encourage, that there is more, that the information about the need for subject matter experts and behavior analysis being highlighted. We're doing that today, so that's good news. This is part of it. That the access to the information be more readily available. If I have to contact somebody to track down this information, that means, first of all, I may not even be aware it exists. We're trying to deal with that issue. But I think that, I encourage the department to look at making the information more readily available on the website, so I don't have to link to a news report or a newsletter to find it. I know I'm starting to sound like a grumpy old man now, but it's also just a fact of behavior. And I also encourage them to look at, is there some way we can make the application process less onerous? Because those two questions you showed, those are the easy ones. I do happen to know when I went to school and what I majored in. And I happen to know what licenses I have. And then it gets more interesting to some extent. Again, the more active you've been in the field, the more work you have to do. So, to quote the great Rod Serling, submitted for your consideration.
Thank you, sir.
Dr. Borland, this is Katie Bryce. I'll give a quick update that I have. I'm submitting the web form, the help desk ticket to have it submitted on our web pages right now. So hopefully it will be up soon.
Gordon Borland here. That's awesome. Thank you so much. But I got to tell you, that doesn't surprise me, because in my experience, TDLR has just been so efficient and so good. Once they become aware of something, you guys do an awesome job, in my opinion, taking care of business, as we say in Texas.
Thank you, sir.
Thank you. Any other questions or comments regarding this? This is so helpful. Thank you so much.
Thank you, sir.
Frankly, I hope that presentation is the recorded version of you doing the voiceover, or the slideshow itself will be available. I think that would be a really good resource for people across professions.
Thank you, sir. We will consider that.
Thank you.
Mm-hmm.
Other comments or questions? Hearing none, thank you so much, Ms. Cox. Really appreciate you doing double duty today.
Thank you, sir. It was my pleasure.
It's been so helpful. Next item on the agenda is work group reports. And I believe we have one work group report, if I'm reading the notes correctly, from the education examination work group. As I understand, Dr. Sokolowski, you'll be presenting the report from that group. So if you would proceed, please.
So are we ready for me just to read that report? Okay. Just as a little bit of background, this is regarding the human trafficking training. And what I did was I contacted the BACB board, who is the licensing board for behavior analysts. And what
Excuse
we
me,
did,
Gordon Borland. BACB is what? I'm sorry, it's the certifying board,
it's the certifying board for behavior analysts.
not licensing board. Just want to be.
Oh, I'm sorry. Just
Thank you.
have it.
Mark.
We're talking about
Yeah.
license. So it is the place we go to take the exam, pass the exam, and we send our continuing education to that board to, that's how we get started. And so what we did was we got their input about what they do and how they address it. And we basically created a response that basically mirrors what the BACB proposes or does. Okay, just for that background. So I will read our response, and it's also in your document. The Behavior Analyst Advisory Board's Education and Examination Work Group, consisting of Lori Snyder and Dr. Stephanie Sokolowski, reviewed the human trafficking prevention training required under the Texas Occupations Code, Chapter 116, to determine if it should count for continuing education, CE, related to license renewal for licensed behavior analyst and licensed assistant behavior analyst in Texas. The Behavior Analyst Certification Board, at BACB, the only certifying entity for behavior analyst and assistant behavior analyst that has been approved by the department, has 3 categories of CE for CEs: learning, teaching, and scholarship, as shown in the table below. And you've got that table in your information. Behavior analyst and assistant behavior analyst must comply with BACB CE requirements. Texas imposes no additional CE requirements. BACB allows CE courses that address, quote, any aspect of behavior analysis, practice, science, methodology, theory, or the profession. There's no close quotes. I think that goes there. I'm not sure where the close quotes would be. Continuing education units, CEUs, must cover material that goes beyond the current BCBA, BCABA task list and coursework required to sit for the certification exams. Oh, there's the close quote. Additionally, BACB accepts continuing education in ethics if the course covers ethical issues in behavior and analytic practice or research. BACB states that, quote, ethics content should relate to the BACB's ethics requirement. Sample ethics topics include the inappropriateness of implementing non-behavioral therapies, strategies for avoiding/managing dual relationships, creating a culture of ethics in an organization, and ethical implications of media and technology, among others, end quote. The work group has determined that a human trafficking prevention training course may fall under ethics in the learning category, see table, if accepted by the BACB and offered by an authorized continuing education, ACE, provider. In a human trafficking prevention course, if a human trafficking prevention course required under Texas Occupation Code, Chapter 116 is offered by a provider approved by both Texas Health and Human Services Commission and BACB, an ACE provider, then the license holder may submit the course certification completion certification to BACB for continuing education approval. Under 16 Texas Education Code Section 121.25A, BACB is the responsible party to determine if the course receives continuing education credit. I dropped my piece of paper. There's one more sentence. Hold on. Here. Okay. The department recommends no amendment of the state of Texas behavior analysis rules at this time. Okay. One thing that we discussed was behavior analysts practice in such a wide range of settings, you know, across really many broad environments that, you know, some may not need human trafficking training specifically. And so we just decided to basically mirror the BACB proposals, what they do. Do you have questions?
This is Gordon Borland. I guess a point of clarification, not for you, Ms. Dr. Sokolowski. The next item on the agenda is discussion and possible action regarding that. So the questions that Dr. Sokolowski is inviting now, would that essentially become part of item H, or is that a separate thing?
This is Katie Bryce, and it should be under the next agenda item.
Okay. Okay,
Thank you.
so Dr. Gordon Borland here. So any additional comments by members of that work group or whatever before we move forward to questions? Dr. Sokolowski, I think you had a.
Okay. Okay, thank you so much. Oh, did you have a question, Ms. Nichol? Oh, okay, you're just moving your arm. Okay. All right. Okay, thank you. Thank you, Katie.
Gordon Borland again. Thanks to the work group for looking into all this. I know it took some time and some research, so we appreciate that. And so now I think we're opening up to discussion and possible action regarding HB 2059, the 82nd legislature, 86, pardon me, and whether required human trafficking prevention training should be accepted for continuing license for license holders. I take it to be behavior analysis license holders, LBAs, LABAs. So, and I want to start with the question just because I want to, because I think it's critical. The TDLR has no option about this requirement. That is a statutory requirement that all licensees must be, not just in behavior analysis, regardless of our field of endeavor. If we're licensed behavior analysts, LBAs, LABAs, then for renewal, we must do this. That's not discretionary. That's not optional. Am I correct in my understanding?
That's correct, Dr. Borland. It's required for certain healthcare professionals.
Correct. Thank you. So Gordon Borland again. So my inference here is what's really up for question today by the advisory board is not, shall we have this requirement? That's not an option. The only question is there some way that it should count toward continuing education credit of LBAs and LABAs? Is that the essential issue?
Dr. Borland, that's correct. Currently, TDLR does not review continuing education certificates from license holders. That's vetted out through BACB. And
Gordon Borland, the certifying entity, whomever that may be.
The certifying entity, correct. And so basically, what the work group recommends is that if the certifying entity accepts the human trafficking prevention training course, and that course was provided by an HHSC approved provider, then it would be up to the certifying entity to determine if it would meet their continuing education requirements.
Laurie Snyder. Katie, does that mean that y'all open the presentation, that y'all share it for other providers to, because it has to be y'all's provided course, correct? And then y'all allow another entity to do your course, or that it just needs to meet all the points within your course to meet your requirements?
This is not a TDLR requirement. This
Well, the
is a
state-
requirement that the legislature passed, and HHSC, Health and Human Services Commission, is the agency responsible for approving the content, approving the providers. They are the ones in charge of it. And so we just have the responsibility to make sure that our licensees complete the course before license renewal, but we do not have anything to do with the actual approval of the course or the providers of it.
Okay. So statewide, there can be other courses if approved by HHSC.
And there are, at first there was just one, and it was the free course, but now the last time I looked, there were at least 10. There are more people getting approved all the time.
So this is Gordon Borland. One of the things that, as I understand, for the BACB as the certifying entity to approve a role, is that they don't actually approve courses. Okay, I want to be real clear on that. I assume I have before me, maybe you can say, whoa, that was fun. The BACB ACE Provider Handbook, the Approved Continuing Education Provider Handbook. And I think that kind of answers the question before us. It says the BACB does not review or approve individual events offered by ACE providers. That's on page 2 of the document. Okay. So if the request or the recommendation be that the BACB approve it, they don't do that. Okay. That's up to the ACE provider, who could, if I understand, potentially develop some sort of continuing education course regarding human trafficking that would include behavior analytic content and tie the whole thing to from a behavior analytic framework, which I think could be done. But the BACB itself does not provide its stamp of approvals, at least in terms of the regular authorization there. So the statements regarding it's basically any continuing education that's acceptable through BACB as a certifying entity must specifically address aspects of behavior analysis, and it's intended to be more than entry level. It is geared specifically for behavior analysts, for people who have passed their certification requirements, have met them, received their credential, and then this goes beyond what's in their minimal license certification requirements. So I guess I'm kind of confused at this point. So I'm hoping someone can help me emerge from that confusion, because I understand the workforce's, I think I understand the workforce's recommendation, which is that no change in the regs, and because that's not possible anyway, because it's statutory. And TDLR is not in the business of offering continuing education. It only has to basically receive documentation of some sort that it is required. I'm not, in one sense, I'm not sure we have much to talk about this, unless somebody who is an ACE provider for the BACB actually develops a specific training program regarding human trafficking that is behavior analytic in nature and is approved by HHSC. And it could be done, but that's kind of where we are, I think. But
Dr. Borland, this is Katie Bryson. I think that's correct. It would be up to a provider. Say there was a provider named Brilliant Education, and they are an ACE provider and they want to develop a course, then they would have to get it approved by HHSC. And since they're already an ACE provider, then they could offer that course and someone could take it, a licensee could take it. They would submit that certificate to the certifying entity when they renewed their certification, and it would be up to the certifying entity to determine if it meets all of their qualifications. But there really isn't any action on our part necessary.
This is Gordon Borland again. I appreciate the reassurance. That seemed to me where this was headed. Just for information for the board or people who will be watching this now or later. If someone thinks that some continuing education for a behavior analyst who are certified under the BACB is not adequately behavior analytic, then the relief is to raise that, make a complaint to first with the provider, presumably, and then eventually to the BACB. But that's only about the behavior analytic part of it. HHSC has nothing to do with that. TDLR has nothing to do with that, if I understand. Yes,
Katie, Laurie Snyder here. Just to clarify, how are licensees given this information that should we adopt this, that if a provider did come available, how do they know that if that is not available, that they have the other option to take it through one of the other to meet their license requirements? And where do we differentiate that this is a license requirement and not a certification requirement?
It's on their renewal application. So when they apply online, it is stated several times in the renewal application. And there is a link provided to the HHSC page, I believe, that lists where you can find the approved courses. So that's how they're given the information. And it's also on the web page and has been emailed out to all of the licensees who subscribe.
So this, Laurie Snyder again, this is just clarifying that what we were attempting to do as a work group, and Dr. Sokolowski, she did most of the work. I mean, she did the work for finding out BACB's the guidelines. But just to clarify for the license holders that it's in the wording that it would state that if there is an opportunity by one of your BACB providers, that it could possibly be approved, right?
We don't currently have a statement up because we haven't made any kind of, recommendation, but it basically would be up to the license holder when they submit their certificates to the certifying entity, then the certifying entity would tell them whether they accept it or not. And they should know that any course that they submit for their certification renewal has to be provided by an ACE provider. So
Right.
they
So-
have to double check that.
So the idea behind that was just that we would be able to, that should those providers come available and the course become available that meets those requirements, that we wouldn't have to reword anything, correct?
Correct.
This is Gordon Borland. So I think we're okay. I think that's the bottom line recommendation of the work group, is that not recommending any revision at this point. Am I understanding correctly, Dr. Sokolowski or Ms. Snyder?
Yes, that's correct. We're recommending no action. It was a point of discussion. We felt like we needed to discuss the issue of human trafficking training, which we had not discussed. So it was that we felt like we needed to have the discussion and make a finding, create a finding, which we did. No action.
Gordon Borland. I think that this was a very important, very timely undertaking by the work group, and appreciate this, because I think this needs to be, provided to the licensees, the public, to understand that behavior analysts don't get a pass on the training, first of all, and it's got to be trained, not just somebody decide to do something, but it's got to be curriculum, syllabus, all that, objectives approved by HHSC. If on top of that, there's an ACE provider that says that they have provided that provides information that in that format or in the format that is appropriate or content that's appropriate to behavior analysts, then that's great. But otherwise, we just have to find something online and take it. Is the way it works right now.
This is Stephanie Sokolowski. Katie, thank you so much for all the work that you did on this.
Yes, thank you.
Thank you. Thank you for participating in it and doing the research yourself also. Thank you.
Yes, if there's anything more on that before we move forward. Hearing nothing more, I agree. Thank you, Katie, and work group, and
And
appreciate your.
thanks to Lori too. Thank you, Lori.
Yes, I was going to say everybody that was involved in the work group deliberations.
Dr. Borland,
Yes, hello.
this is Christina Kaiser again. Would you mind taking a short break to let people get up out of their chairs and move around a little bit, maybe 5 or 10 minutes?
No, I have absolutely no objection. Any concern about that? Let's, shall we say 10 minutes? So we are going to take a break here in the meeting of the Behavior Analyst Advisory Board meeting, February 26th at 11:57 my time. That would give us 10 minutes, which would be whatever that is, 12:07. Okay.
Thank you, sir.
And shall we mute our We resumed the February 26, 2021 meeting of the TDLR Behavior Analyst Advisory Board. So I'm trying to remember, where are we? I see. I think we completed item H, and I believe we are ready to move to item I. Am I recalling correctly, Ms. Luna? Someone? Yeah. Okay. Item I. This is discussion. I'm sorry. Discussion and possible recommendation on the proposed amendments to the existing rules at 16 Texas Administrative Code, Chapter 121, 121.10, 121.21, 121.22, 121.70, 121.75, and the all new 121.71. This is regarding the Behavior Analyst Program. The proposed amendments establish standard and responsibility for delivering behavior analysis services by license holders who choose to provide their services using telehealth. This agenda item includes discussion of the public comments that were received on the proposed amendments and the new section. And I believe Ms. Pefferly, Laura Pefferly, Assistant General Counsel, will be steering us through this conversation. So please.
Yes, okay. First, I want to apologize for my sound bleeding through earlier in the meeting. We were trying to get my sound fixed, and we succeeded, as you probably heard. So, I'm Laura Pefferly. I'm an Assistant General Counsel. I'll be presenting the public comments and the draft responses to the comments on the proposed rules. The rules propose amendments to the existing rules and a new rule section at 16 Texas Administrative Code, Chapter 121. And this is adding rules for the practice of telehealth. The proposed rules were published in the Texas Register on December 4th, 2020. The comment period for public comments closed January 4th this year. We received comments from 3 interested parties during that public comment period: the Texas Association for Behavior Analysis Public Policy Group, TXABA, PPG, the Behavioral Health Center of Excellence, BHCOE, and the Center for Autism and Related Disorders, CARD. We prepared summaries of comments received and draft responses for your review and consideration. At this point, we can modify the responses and/or modify the rule text to a limited extent. If changes to the text are too drastic, then the rules would need to be republished for another public comment period. You can recommend adoption of these rules and make further changes in a future rulemaking as well. Today, you'll need to recommend either adoption with or without changes or another course of action. So the comments are in your packets. You have copies of those. The text I'm going to put up on the screen, but for the most part, the text is not an issue. And unless you have any questions or want to talk about any of it, we only received comments on one section of the rules, and so the concentration will be on that section. But if there are any other parts of the rule that you want to look at, this would be the time. And as I said, we didn't receive comments on those other sections. The public comments that we received for this meeting are not considered in the public comment response that's going to appear in the adoption preamble. It's only the comments that are received during that public comment period. But you can, of course, consider the public comments that we received for this meeting today. So let me share. So this is the section we'll be talking about, but I'll go ahead and start with the summaries of comments and then the draft response, and we can talk about them as we go. The first comment was from Texaba PPG, and they commented in support of the rule amendments and commended the addition of 13 definitions, the requirement for behavior analysts and assistant behavior analysts to be licensed in Texas to provide services to clients in Texas, the addition of administrative practice responsibilities related to telehealth, the creation of a new section for professional practice responsibilities, including the new provisions related to telehealth, and the editorial changes to the Code of Ethics. Texaba PPG commented that the telehealth rules provide a framework for license holders that will result in uniform quality of care and protect the public. And so our response is that we appreciate the support, and we agree that the rules are going to benefit both clients and the profession. And we are saying that we've made no changes to the rules in response to the comment because it's supporting the rules as proposed. So that that will be basically what you will see in the Texas Register when the rules are adopted. Is you'll see that comment and response in there. And so the second comment from BHCOE and CARD, which are the other two organizations that commented, I'll start with my summary of their comments. BHCOE and CARD oppose the use of the word experimental in two subsections of section 121.71, which is on the screen there in front of you. And the place it appears is there in that C2, well, 2A there. And once again below, and I'll roll down to that when we're talking about it. The first place that it appears, it had said the client's consent to treatment that's transitional, experimental, or provisional. And they're saying they don't want the word experimental there. And then down below in that same section under D, they're saying they don't want experimental there. And we have a placeholder in your materials in the rule to reword that, because it said when an established telehealth procedure is not available, a license holder shall notify a client or multidisciplinary team as appropriate that the procedure is experimental. And so that's pretty much roping you into having to use that term. And so we had suggested for your consideration to just reword this, that the effectiveness of the procedure has not been established. But let me go ahead and read the summary of the comment, and then we'll get into the rule text. The BHCOE objects to the characterization of behavior analysis practice using telehealth as experimental. The BHCOE states that the treatment itself is still evidence-based and is administered with the same practice standards of the licensed practitioner. They also expressed concern that labeling treatment administered through telehealth as experimental may affect insurance reimbursement for services. And CARD expressed support, but they also had the same issues with the use of the word experimental. They said that it opens the door to characterizing behavior analysis treatment as experimental. They also raised the concern about insurance coverage, and they cite to the insurance code. The provision they cite to is just the definition of non-quantitative treatment, but the actual provision in the insurance code that is the actual requirement is in section 1355.254B. They didn't cite to that, but that's the one that says coverage may not impose quantitative or non-quantitative treatment limitations on benefits for a mental health condition or substance use disorder that are generally more restrictive than quantitative or non-quantitative treatment limitations imposed on coverage of benefits for medical or surgical expenses. So this is what they're referring to, that they don't want confusion resulting from using the term experimental to, to cloud the waters there. So they suggest that we actually refer to the insurance code, and they also commented that the rule doesn't define what is an established telehealth procedure, such that a treatment would be characterized as experimental if it doesn't fit that meaning, or if an established telehealth procedure doesn't exist. They felt like it's requiring behavior analysis to be labeled as experimental if the mode of delivery has changed to telehealth, and so therefore it's being treated more restrictively than other healthcare services. And they recommend that if we don't change the text, that we clarify that characterizing behavior analysis as experimental is not a basis on which insurers or health plans may deny coverage if the department does not remove the portions of the rule language. So it is in the law that even if you labeled it experimental, that you couldn't base a coverage decision on that if you're an insurance company. They're saying we should put that in the rule. The response that that I have drafted for you to consider would include making this last change, or we have another alternative, and I'll show that to you, maybe putting on the end here that same change, but then for the method, manner, or mode of treatment. I think we have to sort of look at this as two issues, whether the telehealth manner of delivery can be separated from what the actual treatment is. And I feel like that's true, because if a treatment is, there's a lot of evidence for a treatment, and it's, it's evidence-based, it's established, it may not be established for delivering it via telehealth. And this was something that we did talk about in the work group. And so that's something to keep in mind, is how much do we want to distinguish between an established telehealth procedure and an established telehealth procedure or an established treatment procedure that's delivered in person or as opposed to by telehealth. So the draft response is that we agree that requiring the use of the word experimental to characterize a telehealth procedure that has not been established is not necessary. The rule text in 12171D3 has been modified to require that notification that the effectiveness of the procedure has not been established is required, and the license holder may use any appropriate descriptors applicable to the treatment or the method of delivery of the treatment. In addition, the word experimental has been removed from 12171A to avoid a misinterpretation, but the license holder remains obligated to accurately describe the support for the effectiveness of both treatment and treatment provided using telehealth. So we can look at that first one, and you can make a decision as to whether or not you feel like the word experimental needs to be there, or if it just said if the treatment that is transitional or provisional or for which effectiveness has not been established is sufficient. And so we need to make a decision about removing that word experimental. So I'll go ahead and let you all discuss what you think about that.
Laurie Snyder, I think that the paragraph that talks about, and I don't know if you can scroll back down to the recommendations of the rewording, but I think experimental, that has been a problem for a long time in the state of Texas. Even getting insurance approved for ABA or getting it in our school districts has been the conversation of it not being evidence-based, and we jumped that hurdle, so we definitely don't want to go back to that. So I think that should not be in there, but also in the conversation of when an established telehealth procedure is not available, if someone reads over that quickly or doesn't focus on the word procedure, the conversation can really get into the, in a situation where insurance providers may direct people towards one particular provider, where does it being an established telehealth procedure, where is that outlined, what is and what isn't? And does this open up providers from being secluded in their telehealth services because of that wording?
Thank you, Ms. Snyder. And I think Dr. Mock had some comments also. We'll come back, Laura.
Yeah, hi, Dr. Joyce Mock, and I agree with the rewording and taking out experimental in the first one. And I think in the second area, the second option is better because, we would look at whether a procedure is effective. There may be literature that says it is, but it may not be effective for that particular child or patient. So, I mean, in terms of whether something's effective is basically whether it works for that person. Anyway, so it's kind of, I like the second option that you give there.
Mm-hmm.
And I'm wondering also if the behavior analysts in the group have any thoughts or any thoughts about how this, any further thoughts about how this relates to payment issues and with different insurance companies.
Laurie Snyder, also, if I know if it would be too redundant, but if in that the effectiveness of the procedure has not been established for the method, manner, or mode of treatment through telehealth, so that the conversation is that we're talking about that it's not been established that the method, manner, and mode of treatment through telehealth specifically is being discussed in that little statement there, even though I know the beginning of the sentence may address that. I think it's probably more important to highlight that that those method, manners, or mode of treatments might be good in behavior analysis, but maybe that hasn't been established specifically as how it's directed through telehealth. If that makes sense.
This is Gordon Borland. I definitely have some comments, but I think others should probably have a chance to get their word in. Yes,
I'm sorry.
Doctor. Other comments?
Yeah, Dr. Joyce Mock. I also had a question about if there is anything in here, and I didn't see it, that specifies by a video versus audio only method, which I think is a really important distinction because I know that there has been some phone call that's been approved. I don't know that we would agree with that or not. So I'm wondering if that we need to specify the visual.
Laurie Snyder, also the conversation of Dr. Mock, what she just contributed is, or question is, but what if the procedure is consultation? You wouldn't want to, if that was consultation like with a provider and that's providing consultation services, you might not need to have video. And Gordon, I don't know if I'm correct in that, but I'm just thinking in terms of when you're giving direct consumer services, it would be probably maybe the video would need to be present, but not if you were consulting. I don't know about that.
This is Gordon Borland. Yeah, excellent points. I agree. I have some comments to make. One, just not in order of priority or in order of if they occurred, but with respect to telephone, would telephone consultation count as telehealth? I think it's entered in the definitions. Here on I'm looking at page 3 of the proposed rule, item 25. 2526 25 says telecommunications, interactive communication by two-way transmission using telecommunications technology, including but not limited to sound, visual, images, or computer data. 26, item 26 says telecommunications technology, there's computers and equipment used are capable of use for purposes of telecommunication other than analog telephone, email, or facsimile technology and equipment. Telecommunication technology includes, but is not limited to, and then it goes to three items there: compressed digital, interactive video, so on, clinical transmission, data transmission using computer imaging, and other technologies. So it looks to me like that just telephone communication does not count as telehealth, as I understand it. And I think there's other state regs and rules, and Ms. Pefferly is probably better informed than that I am, that specifically talk about what is and is not telehealth or telemedicine in the broader sense. You could add any light on that, Ms. Pefferly?
Well, and any terminology that's associated with telemedicine is, if it's provided by a physician, there may be requirements. And so we need to focus on what telehealth for health professionals is encompassing. And since it's in our own rules that telephone alone is not considered telehealth, I think you can interpret that to mean that strictly using the telephone is not going to be sufficient to be considered telehealth. An occasional use of just the phone without video, I don't think is going to be unreasonable. And so I would say in this section, you probably don't want to try to get too specific about what you're trying to cover here. It's when you're practicing telehealth as we have it defined. This part here is about the consent of the client to what you're going to be doing, and your obligation to be frank about whether the telehealth treatment you're recommending is established and the effectiveness has been proven, both for the treatment and for the treatment using telehealth. And so this is not saying you have to guarantee anything. It's saying you need to inform them. You need to get their consent that they agree to this treatment provided via telehealth. And so I would say that the issue of whether it's by phone or not, that's basically another issue. And in this section, you probably don't want to get into those details. Okay, go ahead.
Gordon Borland, and I agree. Page 7, section 71A, let's see, 2, capital A, that is consent to treatment. It is not, if I understand correctly, that is in general, that is not specific to telehealth. And I think that actually is pretty consistent with for instance, the BACB is certifying agency as their expectations. And specifically says that you have to, that the consumer or their representative is to be informed if what you're using is experimental. I certainly understand and appreciate the concerns about that. And but I think that A is not specific to telehealth. This is for all license holders. And I think we should tread carefully about, making it easy for people to think that something that that has never been evidence-based, has never been validated, is okay to use. And I think, and I know we all agree with that. I know our colleagues at BHCOE or BCHOE, I'm not looking at the document right now, and CARD certainly would agree with that. But to react to some of the comments by those two entities, I think that there may have been some confusion about what the issue was here, because in no wise does anything in this document or the proposed rules or changes thereof indicate that ABA or behavior analysis is inherently experimental. I understand, Ms. Snyder, that is in fact exactly what the insurance companies were saying regarding behavioral intervention, ABA intervention for persons with autism years ago, and I fought that battle with them, so I I understand that. And the answer is no, it's not. The evidence base is clear. But the issue I think that's really germane here is that what is having to do with telehealth. And I think that some of the people responding were somehow concerned, or that the proposed rules would indicate or declare or suggest that telehealth ABA services were experimental. That is not the case. That is not the clear reading of the material, as I understand it. I also know that in my personal status, I was contacted after the comments were submitted by Ms. Cornack. And I explained to her, here's what's going on. She said, oh, okay. So again, I don't want to speak for her because she can't be asked, is that an accurate representation? I'm just telling you my side of the conversation. But so I think I would agree with their concerns. The expressed concerns were telehealth in general being labeled experimental. It's not. It's not being labeled necessarily provisional or transitional either, just as clearly. But it is in fact the case, and this is, I think, germane to something you raised, Ms. Snyder, that the mode of application is germane. Telehealth is a mode, as I understand it, the mode or manner of application. Functional communication training is one we well know within behavior analysis, right? But then there's doing it in person, that's been documented amply as efficacious and valid. Then it's a separate issue is, can we do the same thing, do functional communication training via telehealth? Different issue, okay? Which is, if the answer be not at this time, has it been become established practice? That has nothing to do with doing it in person, nor does it mean that that won't become. To give you some information here, I've been fairly involved with the looking at these issues within the Texava Public Policy Group. We had a task force on telehealth ABA looking at these very issues. The question is telehealth totally experimental? The answer is no, it's not. But some applications of telehealth ABA have been established or well established. Some applications are, others are not. There's reports that have been published, made available, distributed in that effect, and at this time, direct intervention between the therapist on one end of the computer or the camera and a client on the other end has not been as yet adequately demonstrated within what are the accepted standards of the field. It may be shortly. Research is ongoing, but doing assessment, like as FBAs, that's adequately documented in the literature. Doing training and ongoing training and guidance for an intervener is also well established. I mean, that's there in the literature. So I'm just going to say, I personally have no problem with the word experimental being in there. If, however, because I want to make sure that we do not water down how people will interpret it. On the other hand, I don't want a particular word to cause people to stumble over what would be appropriate usage of telehealth ABA. But I wouldn't want them to think they have the green light to go with anything, because in fact, the research base, the evidence base does not yet exist to do directly administered through telehealth some ABA procedures. But doing them while we are consulting with and guiding and tutoring a intervener via telehealth, yes, that's amply demonstrated. So that's my rant, and I'll stop now. Ms. Snyder. You're muted, Ms. Snyder.
would there be a way to do aspects of an ABA procedure, maybe use the terminology or another word other than experimental, just not wanting, with the idea that not wanting to associate that particular word with ABA after such a huge hurdle, getting over it for so long. It's a touchy subject in insurance companies that maybe haven't evolved, or insurance adjusters that haven't evolved, or claim processors or whatever, going back to that old theory that it's experimental and looking to decline claims because of that particular word is always a word used in reference to declining claims. So, you know, maybe identifying there that some aspects of ABA procedures have been evidence-based and some may not be, but a different word other than experimental.
This is Gordon Borland. Yeah, sure, that could be done. I'm not sure that adds any clarity. I think it potentially further just leaves the thing in turmoil, because that's the case. Because something that is as yet not empirically validated, whether in person or via telehealth, in 6 months may be, depending on how the research evolves, the rigorous research. And there are standards for evaluating that. For instance, there is just published the work from some people, primarily here in the state of Texas, are just accepted for publication in the Journal of Applied Behavior Analysis, a research review, a qualitative review authored by Dr. Leslie Neely and others here in Texas, that actually looks at all these things and basically comes out with that recommendation, such as I'm stating. Again, and I'm just going to comment about from my experience as insurance companies. This is my sole personal experience. But I find that they can, you know, in my personal experience, insurance companies have been very creative at finding ways to attempt to perhaps not necessarily pay for coverage and it's not limited to ABA by any stretch of the imagination. I mean, I happen to know that Blue Cross Blue Shield of Texas earlier this year had said, had put out information that earlier this year they were going to discontinue paying for any telehealth. Well, that's an issue with the Department of Insurance and so on and so on, and stakeholders got involved, and apparently that's not going to happen, or at least not at the time they said. And this is before any of this language has come out. I don't think that including the word experimental there implies anything about telehealth ABA being inherently experimental or ABA being inherently experimental. And if one reads it in context, I think it's very clear. On the other hand, if that's a stumbling block, then if we can get across exercise the same control of behavior by behavior analysts without using a word that may be problematic, well then, fine.
Laurie Snyder, maybe unvalidated instead.
Gordon Borland here. I think transitional or provisional essentially says that. I don't think, if we're going to take out experimental, I strongly suggest that we not add another potentially controversial word.
Right.
That's my thinking. But others need to weigh in, perhaps, or Ms. Pefferly.
Well, in my impression during the work group meeting when we discussed this was that no one raised an eyebrow about using the term experimental, but I think that's because it has a certain meaning to behavior analysts that it won't have to a lay person or an insurance company person. And so if we just don't want to set off alarm bells and you're comfortable with leaving it out, that's probably the way to go, because you still have to be frank and use candor with the client that, there's not a huge evidence base that this is going to work using telehealth, but if you want to try it, we can try it, and your insurance should cover it, because even though it's, not proven beyond a reasonable doubt, they're willing to cover that. I think experimental or unproven, words like that may say, maybe like, oh, they're admitting that they don't know if it's going to work or not. They're just, trying it on the fly. And that's not the impression I got from the work group, was that transitional or provisional or experimental all meant that, no, there wasn't this huge body of scientific evidence that delivery by telehealth was, proven hands down, but that it was probably still as effective. And how are you going to ever prove it if you don't start doing it? So That's my feeling, is just that that word has more meanings than one, and it sets off alarms for some people that it wouldn't for others.
Dr. Sokolowski.
I've got a question. Gordon, in your rant, you did say has not been established at this time. Would it help to add in this statement, A has not been established at this time? Would that help or hurt? Or not?
This is Gordon. I don't know. I think that's more, Ms. Pefferly is better prepared to address that. I mean, I wouldn't object, but I don't know that if it buys us any extra mileage.
I don't
You
know.
want that?
What do you think, Ms. Pepperly? What's your opinion?
Well, if the effectiveness hasn't been established yet, that means that it's still a work in progress, and it hasn't been discounted. It just
Okay.
hasn't been demonstrated yet. So if you feel comfortable having that in,
Yeah. Same. Yeah. Okay. Just thought I'd throw that out. Ms. Nichols, you got stuff to say.
I do.
I can't see, so please. Yes, Ms. Nichols.
Oh, hi. Oh, hi. Sorry. So with the pandemic, it's been really hard for parents to find a way to get their kids the care that they need, and they're watching their kids kind of regress and fall back. And the last thing we need is something that will prevent providers from being able to provide any kind of care that will help out during this time. So if the word experimental or anything in that realm is going to prevent insurance companies or give them any kind of excuse to not cover services right now when our kids need it, even though it's not perhaps as effective as it would be in person, I think we need to avoid that right now. Now, there are some kids where telehealth is going to work. There are some kids where it's or adults where it's not going to work. And letting the provider decide that on an individual basis, case by case, I think is appropriate. But I don't think that right now it's a good idea to limit those providers. I think it might be a good idea to continue keeping an eye on the situation and making sure that we are perhaps, I know you mentioned that this is a work group, that the work group is continuously providing information, up-to-date research that has been published about this, and maybe saying in the rules that the board will continue to through proven methods, published proven methods, and so on, the board will continue to monitor this. I think that would be totally appropriate. But saying right now that it's experimental or anything in that nature might, I mean, it's really going to hold parents back. And we really do need the support right now. It's really hard. So that's my 2 cents.
This is Gordon Borland, and thank you. I appreciate that perspective and input. I think that's important that we hear. I do want to be clear. At this point, the rules, if the revised rules were in effect, they would not prevent anyone from any behavior analyst, any LBA, from providing any services they thought were appropriate for a particular client. That is not what this says. What it says is they must acknowledge that and then make sure that the consumer is able to make an informed consent, just like I would if I were working in a clinic and I had a patient for whom I had a procedure. I thought, I think this would be a great idea. It's a great, I think, a novel application of behavioral principles, but it's not been validated yet. I could still do it with the appropriate information provided to the legally authorized representative or the client, him or herself. I can still do it as long as the relevant persons consent. Same with telehealth. Nothing is ruled out. It's just saying we must know what is already established practice in terms of mode, manner, methods, and what is not, and where we're recommending in telehealth, just as in person services, if something is experimental, transitional, provisional, we have to tell the family that. That's it. I mean, I think this is a protection for the public. I think this language in the consent is very important. And then similarly, if I may, and then similarly in the other citation there on page 8, item, whatever it is, D3, I think that's basically what it's about. It is not a preclusion necessarily. Well, it doesn't talk about that. It's a consent issue. It's openness. It's information. Now, so I think the question is, do we want to include the word experimental or not? Okay, that's a different issue. And in my understanding of the operation of the board and the whole behavior analyst licensing program, everything is up for review continually. I don't think we need to put language in there specifically to that effect. That's the case about every intervention by a behavior analyst, or I hope in every profession. I can't speak for what they call experimental or not. I'm not on their board. I don't have that training or expertise. I can just talk about behavior analysis. So I don't know if that helps, if that allays concern, engenders concern. I don't know, but I think those are important perspectives to make sure are very clear.
So do you feel that insurance companies will use this as a way to deny coverage?
I can't speak, this Gordon Borland again. I cannot put myself in the shoes of an insurance company. I think that the duty to inform the public when something is not empirically established practice already exists. This is not new. Okay, this whole notion is not new. It's been there before. It is an obligation of persons certified by the BACB. In fact, it's spelled out very clearly. So this is not a new expectation. Insurance companies could do that already. As I've said, I've had personal experience where they did years ago in person. And then we were able to provide the research base and said, oh, okay, never mind. So I think Ms. Bryce has a comment. Can't hear you.
Sorry. I was just going to offer a different way to word this, the 2A. I don't know if you all will agree with it or not, but I think it can be simplified, and I think it still gets the gist of what you want. If we worded it something like this is just totally rough off my head, but if it said, if a treatment's effectiveness has not yet been established, the client's consent shall be obtained prior to treatment. And we could just leave it at that. Does that still cover what you want, or?
Less is more.
That's what I mean, generally in rules, less is definitely more, because you don't want to get so specific that you totally limit yourself. And so if we just say, if a treatment's effectiveness has not yet been established, you must get the consent prior to providing it.
So this is Gordon Borland. I think that's redundant and congruent with the less is more concern. I think that the notion shall obtain the client's consent before treatment is initiated is exactly what is already being addressed. I think it's redundant.
Do we even need this? Do we even need this A? I mean, we already say that they have to get a client's consent before a treatment plan is initiated. So do we even need this?
This is Gordon Borland. I think yes, because it puts
Laura Snyder, it's on method, manner, and mode of treatment is not addressed anywhere else, Gordon? Is that why we have that in there?
Okay, this is Gordon Borland again. What we are talking about is that trying to make clear that if a practitioner is recommending an intervention, in person, telehealth, whatever the manner mode, it doesn't matter, is that they must acknowledge that, be openly acknowledge, directly acknowledge that to the person who is authorized to provide consent and tell them that. Then they can decide if they want to consent or not. I think 2A is very important. We've known of instances in the field over the years who have come up with what they think is a novel twist on some behavioral application or behavioral principle and done some, I think, to use the technical term, god-awful stuff. We've seen that happen over the years, over the decades. So I think having this kind of language is important. I personally am suggesting that we not add that additional clause. I think it's latent within the whole section in 2A. But I do think that it needs to be clear that if you're going to do something that is not established within the field, then you have to be upfront about that. And the responsible person has to then say, okay. And if they do, well, then you're good to go. That's really all this is saying, whether it's telehealth or and then the second location has to do more specifically with telehealth. I think this introduces no new obligation on licensees that they don't already have per the BACB as the certifying entity. And I think for the public, having this explicitly spelled out in the rules, I think could be reassuring if they looked at them or were told that it was there. I don't know. Other comments?
Laurie Snyder, there was conversation in one of the letters of recommendations that had been presented to us. And there was some wording in there, and I wonder if it's not up above, but that as with all medically necessary treatment, clinicians must identify those patients for whom telehealth can be effective and often must modify treatment protocols, procedures to optimize effectiveness for each service delivery mode. In the absence of rules and regulations, clinicians remain limited to providing services that are clinically appropriate, a determination that is individualized for each. I think where that is important in that comment is that you're not going to have a behavior analyst suggest telehealth when they know clearly that hasn't been identified that it would work for that particular client. And still keep providing services and getting paid for that, which I know that overall, just as a BACB provisions in your certification, that probably covers all of that. But I just wonder, in reference to telehealth, if we've outlined that correctly.
This is Gordon Borland. My answer is yes, I think we have, and I think we need to be very careful about adding additional exposition within the regulations. What is said there is certainly probably okay, but I don't think we need it within the regulations. It's not required by statute, of course, but I think that is adequately handled. It's at least latent. I think it's clear there. But again, I think we need to be clear when we're talking about evidence-based procedures. That does not mean that, oh, it worked for this client, so it's okay. Then it's evidence-based for that client. No, that's not what evidence-based means. It has to do with a set of practices or procedures that have been shown to be overall effective. It is not determined, oh, okay, it's evidence-based because it worked for this client. No, that's not the way the evidence base is determined. Evidence base is determined based on research that rigorous research that looks at the application of that, or the application of that particular intervention in general, not with a specific person. That may not help any, Ms. Snyder, but I've attended ARD meetings where people have made that kind of argument and said that's an important piece of information, but that is not what evidence-based means. There's already some state of term of art, within what evidence-based means. So anyway, if I don't know, I'm thinking maybe we may be getting close to the point of making a motion, but I don't want to preclude anyone else's comments or questions. I think Ms. Sloan maybe have some.
Yeah, I would like to just say a little bit. This is Carol Sloan. I do appreciate the concern about the word experimental for the general public and for how people might associate that in the wrong way with behavior analysis. And I do also feel like, don't you think that the rest of that sentence, the rest of what it says basically the same thing, for which its effectiveness has not been yet established. So I think, Gordon, you said you're fine with taking out the word experimental. I think it does say what it needs to say. The other piece is the concern for kind of the standard of care. While we're in this certain environment in which you can't safely see people face to face, we have one set of treatments, and then what happens when we go back? And Laurie Schneider mentioned the fact that you can have people who are really happy to continue charging a client for which they're not really doing much good because they're not getting the right kind of hands-on practice they need. They're continuing to do telehealth. They really need to refer to someone who can be there in person. So I don't know if we can address that in here, or if it needs to be addressed in here. That's a concern. But I do think in what we're talking about now, taking out that word experimental, that one's fine with me. And I think it does, I can see how people would have some problems with it.
Yeah. Thank you. So, Gordon Borland again. I think, as I said, I think experimental is okay, but I'm okay with taking it out because I agree that we don't lose the base point, as Ms. Sloan had said, by doing that. Behavior analytic work is going to keep moving on. Keep in person or whatever. And in fact, if a person is a provider, an LBA, is providing behavior analytics, trying to provide behavior analytics services through telehealth, and they are not effective, then they have an obligation, already existing obligation, to deal with that. It's also the case, in the field. I'm hearing interesting sounds. We know that some procedures do not readily translate through telehealth. I mean, of course, just like in medicine, that's the case. But and there have been, and the behavior analyst then needs, if their work that they've been doing in person does not readily translate into telehealth modality, then they are obligated to make a change. And certainly we all know, and I know from interactions with colleagues in the field, is that the focus of ABA intervention sometimes that is being done at home by parents or maybe by RBTs or someone other than the LBA, him or herself, has to change because there's different priorities at home. And that is an obligation, that is an existing obligation already. Sometimes a lot of the discrete trial training that was going on in clinic does not readily translate into telehealth, of course. But there's other things that can, and there's been some excellent work published, it's valid, even from people here in Texas, imagine that show that you can do these kinds of, make a transition. There's some documents already existing, for instance, on the TexABA website, but that talk about how one needs to tailor the services, ABA services one provides, perhaps from the transition from clinic to telehealth, and then telehealth back to clinic we're looking forward to. So, but I think that's a pre-existing standard that already exists. So I think someone has entered maybe some alternative language there. Is that Ms. Pefferly? If you want to tell us about that, please. It looks to me like the highlighted part there, A, and it highlights is the original wording with rephrased with the word experimental removed. And one or.
Dr. Borland, I said, this is Katie Bryce. I suggested this language just because I think it reads a little better, but still maintains the same, my mind just went blank. That it basically says what you're saying in the original A, but it just reads a little better, but I just put it up there as a suggestion.
Okay. Gordon. Borland.
Laurie Snyder, I'm just a little bit hung up on the word regardless. Should that be more something along the line? Because that, to me, I read that as in basically, since we don't have validated research on each method, manner, or certain modes of treatment, it almost seems like it's saying that no matter what, if you do telehealth, you would have to get.
Gordon Borland.
Or would it be through instead of, Laurie Snyder, through, the word through instead of regardless, through method, manner, or mode?
This is Gordon Borland again. I completely agree with you, Ms. Snyder, that regardless, I think is potentially a landmine there. I think we just want to be really careful about how much we add. We want to have what we need, but be careful here. So I'm trying to understand, Ms. Bryce, what this adds. I'm perhaps my eyes aren't working fast enough.
Snyder, I think she's still trying to keep the method, mode, and manner part in there, but I think that because of what you were saying with the research, that there is some research with certain parts of it, but not.
Yeah, Gordon Borland, I guess I'm not understanding what we gain by rephrasing it there, other than compared to just striking experimental. The words method, mode, or manner are already there.
Right. I just thought it read better to say up front, the client's consent to treatment shall be obtained. That didn't come over here, but it had said shall be obtained before all of this, instead of in A where it basically says the consent has to be obtained at the very end. I just moved that part to the beginning, but it really was just a suggestion.
Laurie Snyder, I like that, but could we just put for which established for the method and just stop, not duplicate that second sentence at the end? For which established for that has not yet.
Yeah, we got the Gordon Borland. We have established not yet been established appearing twice in there. Right.
So it would be has not yet been established, and instead of that comma there, right, the line right above your cursor blinking, it would say for which its effectiveness has not yet been established for method, manner, or mode of treatment for which the consent is being obtained.
This is Gordon Borland again. The more I look at it at the moment, the more I prefer the original phrasing. I understand that it's nice to have the term about client consent. It's up front. Sure, I agree. I don't know that we need to say, okay. I guess in the original version, we talked about consent twice, but I'm just not sure what we add by adding the second variant of A, by the highlighted version of A. I'm not sure what that gets us, and does that eliminate any possible complication, assuming we get rid of experimental?
Could we try it this way? Could I make a suggestion?
Please.
For number A, what if it read, the client's consent to treatment shall be obtained before a treatment is provided that is transitional, provisional, or for which the method, manner, or mode has not yet been established.
This is Gordon. I think we want to be careful, but we inadvertently, that there's some conditions under which you don't have to get consent. All this is saying is making it explicit that if you're using a procedure that is transitional, provisional, or whose effectiveness has not yet been established, the person must get consent. The provider must get consent. I think that's all it's saying. And I think we want to be careful lest we insert wording that someone say, "Ah, well then I don't have." It's what I'm doing is neither transitional, provisional, nor is it effectiveness not yet established. So I don't have to worry about consent. I mean, we need to be careful about inadvertently setting the occasion for that misunderstanding.
Do we need for which its effectiveness 2 times? Do we need that 2 times? Or can
This is Carol Sloan. This is Carol Sloan. The original, I'm kind of like Gordon. I like striking experimental. I don't mind adding the not yet been that was talked about earlier, but the way the original words, it kind of focuses on the fact of we're in a telehealth section. We not only will remind the people that the practitioners that you want to be sure effectiveness that you need to get consent for any procedure for which that has not been established, but also when you do change this method, manner, or mode, you're wanting to be highly conscious of that too. So the original with just those 2 changes, I think still works pretty well and doesn't change the meaning of it very much. It wouldn't seem like it would be a change that we would have to worry about.
This is Gordon Borland. I agree. I do want to point out though, 121.71 2A is specific to any behavior analytic treatment. It is not telehealth specific. That is addressed further down under 4D3, the second occasion of experimental occurring. So again, here it's the section 2A is for any behavior analytic thing. And it's just saying, no matter how you do it, you got to get, if it's provisional, transitional, you got to get consent.
Yeah, and you're correct about, that this is in the general professional responsibility section. And then D is actually the that's under the telehealth portion of it. And I think that the A part here puts a point on the fact that the treatment itself or the method, manner, or mode of treatment, the delivery is a separate issue, that you really need to have consent if either one of those is transitional or provisional, or if they both are. I don't know how important that is to you, but I felt like that was probably important to have in the consent that, if one or both of those is not supported as well in the scientific literature yet, and that sort of thing. This does show it that it's 2 different things, more than just kind of trying to combine them. But,
second thought, I agree. I totally agree. 2 separate things. We need that effectiveness both places. I withdraw my comment.
Gordon Borland here. Thank you, Dr. Sokolowski, for the clarification. Okay, where are we here in terms of decision making? Because we need to make a decision. We can either kick the thing and send it back to the work group and start all over again, which means it'll be brought back before the board and then go out for public comment first, and then we come back and do this again as we're doing today, and then at some point it's either okay and we send it to the commission, or we keep massaging it. I think we're close to the point of making a decision, but Ms. Pefferly.
Yeah, if we go with any of these changes that you're seeing on the screen right now, those are not significant enough to have to republish. I can explain those a little better in the response to the comment that we're trying to sharpen it up. It really is not going to affect different people or different subjects. So those are okay. If you want to remove experimental and add, not yet been established there, that's fine. If you want to go with either one of these options down here in D, that's fine. We wouldn't have to republish. you know, if you do want to work on it more, there's two ways to do that. Well, maybe three, I'd say. You can work on it more in this meeting. You can send it back to a work group to work on it some more, or you can adopt it with these changes and then work on it some more and maybe make further tweaks down the line in another rulemaking. So.
Gordon Borland, thank you, Ms. Beverly, for a nice analysis of kind of what the options are. And again, if we do recommend it for approval by the commissioners and they approve it, that it's not chiseled in stone.
No, none of the rules ever are. You can always change your rules.
Always. Statute, that's a different story.
Exactly.
Yeah. Okay, so let's move forward with decision making here. I guess we can look at each instance of the word experimental in turn and decide how we want to proceed, or we can entertain a motion at any moment. How about that?
Would you like to vote on the first one first, maybe?
Let's do that. There was so much discussion. Let's just vote on that, get it done, then go down the way. I
I'll
think
just
that would
show
be
you
the
how
quickest.
it would look.
Okay. Okay, so we're looking at item 2A. The wording there would be as it was originally, but with the word experimental removed. Is that correct?
And yet being added twice.
And yet, not
It's not yet, right?
and or yeah, got it. Okay. Accept open to. Is there a motion to accept this change?
I'll move.
Sokoloski, so moved. There a second?
I second. Carol Sloan.
Carol Sloan, second. Call the question. Ms. Luna, will you poll the members, please?
Yes. Dr. Joyce Mock,
Approve.
Carol Sloan,
Approve.
Dr. Stephanie Sokolowski,
Approve.
Dr. Laurie Snyder,
Approved.
Amanda Nichols,
Approved.
and Dr. Gordon Borland.
Approved.
Motion passes.
Okay, motion passes. Thank you. And then proceeding to the second item in question, which is again 121.71 D3. We have a couple of proposed changes. One would be essentially the original wording with the addition of effectiveness of the procedure has not yet been established. Or okay, and then an alternative to that would be that same language, but the effectiveness procedure has not yet been established for the method, manner, or mode of treatment. So I think what the chair will entertain a motion regarding the first version. Ms. Luna, will you poll the members, please?
Have we had
A motion. I'm sorry. Pardon me. Pardon me. I must be hungry right now. So thank you for that reminder. Okay. So is there a motion to accept the revised version, the item D3? Yes, as revised there in the first version. Is there a motion to accept that?
I so move to approve that or vote on that.
Okay, Ms. Nichols
Amanda Nichols.
moves. Thank you. Is there a second?
I'll second it, Laurie Snyder.
Laurie Snyder seconds. Okay, now. Will you poll the board members?
yes. Dr. Joyce Mock,
I do not approve.
Carol Sloan,
I approve.
Dr. Stephanie Sokolowski,
No.
Laurie Snyder,
I approve.
Amanda Nichols,
No.
Dr. Gordon Borland.
I approve.
So motion does not pass.
What is the count, please?
4 noes and 1, 2 yes.
2 yes or 3?
1, 2. I'm sorry, I counted 2.
Okay. All right. I will accept the official count. Thank you. All right. So then we have, would someone like to make a motion for the move approval of the amended version of D3 there?
Gordon, could I actually just say, could we discuss that one a little bit more to understand what the problems with the first one were that the second one might address?
Ms. Sloan? Okay. Okay. Sure. I'm listening.
I liked the fact that taking out experimental worked there and that says what we wanted to say. I'm interested to know why the others didn't approve of what it is. I don't really like the second one instead, because it only concentrates on the method, and we are talking about telehealth in this particular thing.
This is Dr. Mock, and I like the second because we know that no matter what, if you're using something that the effectiveness has not been established, you're going to get consent for that no matter what. And I like the second version because it focuses just on the mode and method. So I think I think there are two different things. I think that you're always going to get consent if you for any method, if it's an unestablished procedure, and then this just makes it much more specific to this new method.
Gordon Borland, thank you. Anyone else wish to comment on that? Okay, well, let me make sure I clearly understand what would be the case for using the second alternative to D3. Ms. Pefferly, is this the way the whole item would read? A license holder shall provide the same quality of services via telehealth as is provided during in-person sessions. A telehealth provider shall maintain a focus on evidence-based practice and identify appropriate, meaningful outcomes for a client. When an established telehealth procedure is not available, a license holder shall notify a client. Oh, okay, it's moving on. Shall notify a client or multidisciplinary team as appropriate. I assume that the effectiveness of the procedure has not yet been established for the method, manner, or mode of treatment. Is that correct? The highlighted portion does not stand alone.
Right. Yeah, that's just the two alternative ways we've been talking about. And, we are in the telehealth section here. This is just telehealth, this is the focus on telehealth in this part. So yeah, this would just go up here.
Got it. Gordon Borland, thank you. I just wanted to make sure that I was reading this correctly and that we're all clear for everyone on the board and everyone watching.
Yeah, this paragraph would just read just like that.
Okay. Thank you. Any further discussion? Is there a motion to accept D3 as amended as proposed in this version? Is there a motion?
No motion.
Dr. Sokolowski moved. Is there a second?
Amanda Nichols, I second.
Amanda Nichols here.
Ms. Nichols, okay. If there be no further discussion, Ms. Luna, will you poll the members present and voting, please?
Yes, sir. Dr. Joyce Moore,
Approve.
Carol Sloan,
Approve.
Dr. Stephanie Sokolowski,
Approve.
Laurie Snyder,
Approve.
Amanda Nichols,
Approve.
Dr. Gordon Borland.
Approve.
Motion passes.
Thank you. So motion passes. All right. So we recommend, we perhaps will recommend to the commission that they accept this particular amendment to the draft. So my understanding now is that the board needs to vote on recommendation of the proposed modified revised regulation as a whole. Is that correct, Ms. Pepperly?
Yes, the motion will be to recommend adoption of the rules as amended today, and that will include those two parts that were amended, and everything else is exactly the same as when it was proposed. If there is anything else you want to look at or tweak, we can do that. This would be the time to do it because this is your last chance. When these go to the commission and they're adopted, and we'll have to do another rulemaking to change anything again. So, if you're happy with them and with these changes, we're good. If you need to discuss anything else in them, this is the time.
Gordon Borland, thank you for that clarification. So at this point, the chair is open to anyone raising any other questions or concerns about the draft regulations before we proceed to a motion one way or the other. Okay, hearing nothing, chair is open to a motion to accept the proposed regulation as amended today. Is there a motion to that effect? Sokolowski so moved. Is there a Sokolowski, excuse me. Is there a second?
I second. Carol Sloan.
Carol Sloan seconds. Any further discussion? Hearing none, Ms. Luna, will you poll the board present voting?
Yes, sir. Dr. Joyce Moore,
Approve.
Carol Sloan,
Approve.
Dr. Stephanie Sokolowski,
Approve.
Laurie Snyder,
Approve.
Amanda Nichols,
Approve.
Dr. Gordon Borland.
Approved.
Motion passes.
Thank you. Thank you to the board. Thank you for staff for helping us work through all this. I think this is exactly what we need to do, is to have these conversations and discussions. So this is good and helpful, I think. So to wrap up this item on the agenda, I think the motion, the proposed revisions to Texas Administrative Code 121, the various chapters as indicated, 121.10, 121, or sections rather, 121.10, 121.21, 121.22, 121.70, 121.75, as amended today, as revised today, are approved and will be forwarded to the commission, the Texas Department of Licensing and Regulation Commission.
And the new section 121.71.
Oh, did I miss that? Oh, thank you. Thank you. Yes, I want to make sure for the record, we got them all in there.
And that's the one we were talking about. So, yeah.
Such fun. Okay. I think we're ready to move on. Item J, need to discuss possible assignment of topics for consideration to work groups. I think Ms. Bryce had some input on that.
Yes, thank you. For the first item, this is Katie Bryce. For the first item, Ms. Holly Benicosa, Executive Director of the Qualified Applied Behavior Analysis Credentialing Board, QABA, submitted a written request on December 21st, 2020 for the Behavior Analyst Advisory Board to review the Qualified Behavior Analyst, QBA, credential as meeting the requirements for the Behavior Analyst license in Texas. We would like for the Education and Examination Work Group to review this and make a recommendation to the full advisory board.
Okay.
This is Gordon. I've got a question. Am I reading something different here? That's the agenda mentioned referring to the licensing work group.
Oh, I apologize. I believe the last one did go to the licensing work group, so that's where it would go. Thank you.
Okay. What is the composition of the Gordon Borland again? What is the composition of the licensing work group right now? Who are the members?
One moment, sir. Let me look at that document.
With some of the changes in board composition, I want to make sure it isn't just one person
Right.
remaining.
One moment. Work group members. For the licensing work group, can y'all hear me?
Yes.
Okay. I have Dr. Stephanie Sokolowski, Carol Sloan, and Dr. Joyce Mock.
Okay. Gordon Borland, thank you. We have more than one member. We have 3.
Yes.
So, okay. The chair recommends designation of that task as described here as to the licensing work group. We will look forward to your diligent and very careful contemplation and recommendation. Anything else on that before we move on, Ms. Bryce, to the next item there?
No.
Thank you. Go ahead, please.
Okay, under item J2, on January 27th, 2021, we received a request from an individual who holds the Board Certified Autism Professional, BCAP credential, issued by the Behavioral Intervention Certification Council, which is BICC, to accept the BCAP credential as meeting the requirements for the Behavior Analyst license in Texas. We would like for the licensing work group for further review to look at this before making a recommendation for the full advisory board.
Thank you, Ms. Bryce. Now that we know who's on the work group, I'm pretty recommend that it take up this task. If they don't mind having two of these tasks to pick on or to pick up. Is there any concern about the members of the work group taking that one on also?
No, I think the research is going to be similar to address both issues.
Okay. Thank you, Dr. Sokolowski. I'm seeing everyone indicating either saying or by body language that they're okay.
No problem. We'll do them. We'll knock them out.
Excellent. Okay, so we will channel this issue to the licensing work group. Okay. Anything else on that before we move to the next item? Ms. Price?
No, sir.
Okay. Woo! Moving right along here. Item K is coming up. I guess you could see that. I did want to just exercise the chair's prerogative a moment to just mention something. A lot of you may not know this because it's kind of it's been developing, but March 20 has now been designated as World Behavior Analysis Day. Okay. It's not just Behavior Analyst, but Behavior Analysis Day. The first celebration will be March 20, 2021. So it's kind of coming out short notice. There will be an introductory video and so on, but just there's a website. You can go to the University of Google and find it, I'm sure. But within as the board being involved with the practice of behavior analysis, I want to make that known. I personally think this is a really good development. I look forward to 2022 when people can celebrate in person and have more time to get it revved up. So with that announcement behind me, moving on to item K, recommendations for agenda items for the next meeting. If anyone have any recommendations for that? We certain things are standing items. We know that. We know there may be recommendations from the licensing work group that we will consider, but others.
I think I don't know if you guys can hear me very clearly. It's a little.
This is Ms. Nichols, right?
Yeah,
Yes.
sorry, Ms. Nichols. Can you hear me very clearly?
Yes.
Good. Going over the picture, legislative session is probably going to come everything.
I'm sorry. Had some interference there. Something about legislative something.
Yes, just going over everything that happens during the 87th legislative session that's coming up with the sunset review and the bills that are going to be coming up. Looking forward to that and just kind of getting a review. That's probably we probably want to add that to the agenda.
Yes, I definitely would like to have it there. Just to make sure we don't lose track of that. It's all very important. Thank you. Thank you. Ms. Nichols, other recommendations for agenda items for the next meeting?
Stephanie Sokolowski. Thanks, Ms. Nichols. So do we need to particularly address any funding or LAR issues that may be taken care of by then? Or will that be encompassed in the legislation?
This is Gordon Borland. I think it would probably be up in that general recommendation that Ms. Nichols made.
Because funding always is an issue. Okay.
Pardon?
Funding is always an issue. What gets funded and what doesn't.
Yeah.
Okay.
Ms. Luna, did you pick up what you needed there?
Yes, sir.
Okay, I just want to make sure.
You might want to have a work group report from the licensing work group on the research for the items for the licensing work group.
Yes.
Yes.
Yes. Yes. Yes. Thank you. I would also like an update on the SME situation specifically. I'd also like to talk about any vacancies on the board right now, because I believe we have some. How many vacancies do we have right now? I'm seeing at least 2.
Bear with me just a second, sir.
Okay. Okay.
Okay, currently we have we have 3 vacancies on the board.
I believe those are on the agenda for the March 3rd commission meeting, the appointments. So,
Right. Currently
yes.
we do have, that's what we have.
Okay. Gordon Borland, thank you. Yeah, I saw that on their agenda coming up. That's next week.
Mhm.
So I would like to, we probably need to say hello to them. So good. Any other items to add to the agenda? Of course, we have standing items. Ms. Luna?
Yes, and Dr. Borland, as soon as whatever the commission is, whomever they decide to appoint, of course, we send out the notices to the new board members, the existing ones that are getting reappointed, and then you as the presiding officer will receive a copy of that email as well.
Great.
Mhm.
Gordon Borland, thank you. Any other possible item? Again, if we think of others, we can provide that input to staff, of course. I do have a question, and I realize this is not an agenda item. So given the recommendations that were approved today, the proposed rule changes, will those be available for the commission to consider at their March 3 meeting?
I see Delia shaking her head. No, it takes a little time to get those ready. Tentatively, I believe they're scheduled for the March 30th meeting, but these commission dates are subject to change. So, and also the scheduling of these rules at that commission meeting could change. But as far as I know, right now they're scheduled for March 30th. But you can't hold me to that 100%.
Sure. Okay, thank you for that clarification. I was just hoping.
We work fast, not quite that fast.
I was going to say, you guys are so efficient. I could see it. Okay. All right. Anything else? Last call for agenda items. Hearing nothing, moving on to item L. Ms. Luna will be sending an email to the board members with possible dates for the next meeting. So we don't know for sure when that will be at this point. To be arranged, to be scheduled. Any other final comments by the board members before we wrap?
Quick question, just in terms of the committee where we have our discussion, do we just among us set that up, or does that come from someone? How does that work? Anybody?
This is Katie Bryce from OAM. Either someone from licensing will contact you about that, which would be Laura Hernandez, or another TDLR staff member. We usually will send out an email asking for dates you're available and then get it scheduled. So look for something from one of the TDLR staff people.
Borland, thank you. That's been my experience, very helpful. Good input always from them. Okay. Anything else? Motion to adjourn? Dr. Sokolowski, second, everybody seconds. Okay. Okay. I want to thank everyone, staff and members, for attending this long but productive discussion, this meeting. The meeting is now the February 26, 2020 meeting of the TDLR Behavior Analyst Advisory Board is now adjourned at 1:41 p.m. Thank you all.